ಸರ್ ಇವೆರಡನ್ನೂ ತೋರಿಸಿದೀನಿ. ಆ ಸೆಂಟೆನ್ಸ್ ನೀವು ಕಂಟಿನ್ಯೂಯೇಷನ್ ಸೆಂಟೆನ್ಸ್ ಹಾಕಿಲ್ಲ, ಹಿಂದೆ ಮುಂದೆ ಮಾಡಿದೆ. ಸೆಂಟೆನ್ಸ್ ಅಥವಾ ಅಟ್ಲೀಸ್ಟ್ ಹಂಗೆ ಇದು ಮಾಡಿದ್ರೆ ಸರಿಯಾಗಿದ್ದಿರ. ಎರಡಿದೆ ಅಲ್ವಾ, ಇಬ್ರು ಇದಾರ. ಒಂದು ಧಾರವಾಡ ಒಂದು ಇದೆಯಾ? ಇದು ಧಾರವಾಡ, ಇದು ಇಲ್ಲ ಇಲ್ಲ ನಾನು ನೋಡ್ಕೊಂಡು ಇದು ಕಲಬುರ್ಗಿ. ಅವರು ಕರೆಕ್ಟಾಗಿ ಬರಿಬೇಕಾಗಿತ್ತಲ್ವ ಸರ್? ಹೌದು, ಅದನ್ನೇ ಅರ್ಥನೇ. ಆಮೇಲೆ ಏನು ಗೊತ್ತಾ, ಏನು ಬರಿಬೇಕಾಗಿತ್ತು? And already no other, they are already on record and no other legal ಬರ್ದಿದ್ರೆ
benches ಇದೆಯಾ?
Matter pertains to Dharwad bench. Serial number 1, Shivaraj S. Balluli.
Please, Manoj. I appear for the petitioner, Manoj. My sincere apologies, Manoj, on the previous occasion. By the time I logged in, Manoj, the matter was called out. My sincere apologies for that, Manoj. I filed this is IA for recalling, Manoj, the earlier order.
ಅಲ್ಲಿದಾರಾ?
Please, Manoj. I'm audible, Manoj.
Heard the petitioner counsel. Recalling allo madam idu?
Please, Manoj.
ಬೇರೆ ಆರ್ಡರ್ ಕೊಡ್ತೀರಿ? Order on IA number 1 of 25 for recalling the order dated 26/3/25. ಯಾವ್ದು? 26(3).
(26)(3), my lords, the order was passed.
26(3). How many time matter listed before the court?
My lords, before that, my lords,
Before dismissal.
twice, my lords. Third time, my lords, the matter was dismissed. Third time, my lords, the matter was dismissed. 19.3 and 19.3 and 26.3, my lords. Twice, my lords, the matter was dismissed. Second time, my lords, the matter was dismissed. Due to some network problem, my lords, I could not appear before your lordships through VC.
ಯಾರು ಇದಾರ ಅದರ್ ಸೈಡ್ ಇದಾರ?
My lords, served and unrepresented, my lords.
Heard on IA number 1 of 25 for recalling the order dated 26/3/25 and before dismissal. When the matter was listed on 19/3/25, counsel was absent and HCGP was present and also made it clear that if learned counsel for the petitioner doesn't appear on the next date of hearing, the petition will be dismissed. And in spite of the said order, the counsel did not appear on 26/3/25 and hence the same is dismissed. The counsel in the copy serve madidara madam. The copy is also served on the HCGP madidara nodi.
Please.
HCGP and in spite of service of notice, counsel is absent and hence
return of the documents, my lord. They have filed similar application. Return of the documents, my lord. They have filed similar application before the DRT, and at para number 12, it may be seen that, my lord, they have themselves stated that similar application is pending before the DRT. Now the same application has been filed here, my lord. Your lordship may kindly see the operative portion of the order, wherein, my lord, your lordship has directed to deposit 51 lakh before the registry, my lord. And as per that, my lord, we have deposited before the registry. And that amount is subject to the outcome of appeal before the DRT, my lord. Now they have filed this application, my lord. So they can't maintain two applications, my lord, before the DRT as well as the High Court, my lord.
DRT also they have filed an application, similar application.
Yes, para number 12 of the affidavit may kindly be seen, my lord, page number 5. They themselves have stated before in the affidavit, my lord. Page number 5, para number 12, my lord. I stated that I filed similar application before the Honorable Debt Recovery Tribunal on 24/3/25. The tribunal posted the matter for evidence. Despite of request having been made to consider the application for hearing on 13/6/25, when the matter was called out, the advocate could not reach court in time, and the Honorable Tribunal accordingly directed the matter to be posted before the presiding officer on 14/7/25. The application for return of documents is still pending consideration before the Honorable Tribunal. Therefore, my lord, this application is being filed.
Why you have filed two applications, madam? One is before the tribunal as well as before this court. But matter is pending before the DRT.
Yes, my lord.
I think other side six time.
Please, my lord.
Counsel six time. List this matter on Friday.
25.
Please, my lord.
Both connected.
Please, my lord. Please, my lord.
Matter 14.
ಗುಲ್ಬರ್ಗದಲ್ಲೇ ಇರ್ತೀವಿ ಕೊಡಿ ಯಾವ್ದಾರು ಒಂದು ಡೇಟ್. ನೆಕ್ಸ್ಟ್
5/8.
5/8.
R1 ಗೆ GP.
R1 ಗೆ ಇನ್ಯಾರಿದೆ ಬೇರೆ ಇದಾರೆ? ಇಶ್ಯೂ ನೋಟಿಸ್ ಹಾಗಾರೆ issue notice against R2. HCGP is directed to take notice for R1. Third, appellant counsel submits that amendment is carried out and also filed amended petition, and so also the affidavit of Amended affidavit of assets and the same is taken on record. ಏನಾಗಬೇಕು next? You have not filed any application. Not yet filed any application on that. Why you are seeking paper publication in 2018 matter now? Huh. Huh. Then once again, amended petition. Oh, now you are seeking for additional properties also. Then you file an application, that's all. No. List this matter after 2 weeks.
11.
ಏನ್ರಿ ಇದು ಏನಕ್ಕೆ ಬೆಳಗ್ಗೆ ಪಾಸ್ ಅವ್ರಿ ಏನಾಯ್ತು ಮೆಮೋ?
Appellants and respondents are R2 ಅಂತ ಬರ್ತಿಲ್ಲ. And no other legal LRs of deceased are kindly come on record.
ಮತ್ತೆ ನಂಗಿದೆ ನಿಮ್ಮ ಮೆಮೋ ಅಪಲೆಂಟ್ಸ್ ಅಂತ ಇದೆ ರೀ. ಆಯ್ತು ಬಿಡಿ, ಹಂಗಿದೆಯಲ್ಲ ಸಾಕು. ಅದೇ ಆರ್ಡರ್ ಬೆಳಗ್ಗೆ ಏನ್ ಮಾಡಿದ್ವಿ ಅದೇ ಆರ್ಡರ್ ಮಾಡಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿ. ಅದರದ್ದೇನು ಬೇರೆ ಎಲ್ಲ ಆಯ್ತಾ? ಬೆಳಿಗ್ಗೆ MD ಗೆ ಏನ್ ಹೇಳಿದ್ವಿ ಅದೇ ಮೆಮೋ ಡೇಟ್ ಚೇಂಜ್ ಆಗ್ತದೆ ಇಲ್ಲ? ಅದೇ ಡೇಟ್ ಮೆಮೋ ಸೇಮ್, ಬಟ್ ಯುವರ್ ಸೆಂಟೆನ್ಸ್ ಇಸ್ ಇನ್ಕಂಪ್ಲೀಟ್ ಇನ್ ದಿ ಮೆಮೋ. ಲೀಗಲ್ ಹೇರ್ಸ್ ಆಫ್ R2 ಅಂತ ಬರಿಬೇಕಿತ್ತು, R2 ಅಂತ ಬರ್ದಿಲ್ಲ. ಅಪಲೆಂಟ್ಸ್ ಅಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಆರ್ ದಿ ಲೀಗಲ್ ಹೇರ್ಸ್ ಅಂತ ಬರ್ದಿದ್ದೀರಿ, ಆಫ್ R2 ಅಂತ ಬರಿಬೇಕಿತ್ತು. ಆಯ್ತು, ಈಗ ಆರ್ಡರ್ ಆಗಿದೆ, ಮಾಡಿ ಕರೆಕ್ಷನ್ಸ್ ಮಾಡಿ. ನೀವೇನ್ ಹೇಳಿದ್ರೆ ಅದನ್ನೇ ಮಾಡಿದೀನಿ. R1, R3 and 5 appellants and R1, R3 and R5 are the LRs of R2. That is the order, very clear. In the morning I have already dictated. ಕೊಡಿ, 2 ವಾರ ಕೊಡಿ. And then directed to 7-8 and then directed to 7-8. Appellants and respondents ಅಂತ ಅಂದವ್ರೆ, ಬಟ್ ಬೆಳಗ್ಗೆ ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳಿರೋರು R1, R3 and R5 ಅಂತ ಹೇಳೋರು. ಮೆಮೋಲ್ ಇಲ್ಲ, ಬಟ್ ಅವ್ರು ಹೀಗೆ ಹೇಳ್ತಾ ಇರೋದು ಅವರೇ ಅಂತ. ಈಗೇನು R2 ಎಲ್ಲಾರ ಇಲ್ಲ ರೀ, R2ನೇ ಸತ್ತೋಗಿರೋದು. R2ಗೆ ಯಾರು ಎಲ್ಲಾರ್ಸ್ ಅಂದ್ರೆ ಅಪಲೆಂಟ್ಸ್. R1, 3 and 5. 4 ಯಾರು? 4 ಯಾರು? 4 ಯಾರು ಒಂದೇ ಕೇಸಲ್ಲಿ ಅಪೀಲಲ್ಲಿ ಇರೋರು? ಬ್ರದರ್ಸ್ ವೈಫ್, ಸಿ ಇಸ್ ನಾಟ್ ದಿ LR. ಅಷ್ಟೇ ಕರೆಕ್ಟ್ ಆಯ್ತು ಅಲ್ಲಿಗೆ. 1, 3 and 5. ಒರಿಜಿನಲ್ ಸೂಟ್ಸಾ? ಓ, ನೀವು ಹಾಕಿರೋ ಸೂಟ್ಸಾ? ನೀವು ಹೇಳ್ಬೇಕು ನಂಬರ್, ಇಬ್ರು ಸೂಟು. OS ನಂಬರ್ 203 of 238 of 23, 85 of 23, ಎರಡು ಸೇಮ್ ಇಯರ್. ಅಷ್ಟೇ ಆಯ್ತು. 7-8. ನೆಕ್ಸ್ಟ್
12.
ಅದು ಬರ್ಕೊಂಡ್ರೆ ಮೇಡಮ್ ನಂಬರ್ಸು ಅದು ಕೊಡಿ ಅವ್ರಿಗೆ. ನೆಕ್ಸ್ಟ್ ಯಾವ್ದು ಮೇಡಮ್? 12. ಕುಮಾರ್ KG ಹೇಳ್ರಿ ಏನಿದು? Council submits that amendment is carried out and also filed amended cast title. List this matter on admission. Admission on 7-8. 22. Memorandum of compromise petition ಏನ್ರಿ ಇದು? ಕೊಡಿ ಏನು? The name of Basuraju mentioned as respondent in the cast title of compromise petition is not forthcoming in the cast title of RS ಅಂತಿದೆ. ಫ್ರೆಶ್ ಆಗಿ ಆಗ್ತಾ ಇದ್ದೀರಾ? ತೋಳಿ ಇಬ್ರು ಪಾರ್ಟಿಸಿದಾರಾ? ಕಲೇಶಪ್ಪ ಯಾರು? ನೀವಾ ಯಶವಂತ ಲ್ಯಾಂಡ್ಸ್ ನ ಅವರು ಲ್ಯಾಂಡ್ ನ ರಿಲೀಸ್ ಮಾಡ್ತಾರೆ. ಸಿಸ್ಟರ್ ಇಸ್ ರಿಲಿಂಕ್ವಿಶಿಂಗ್. ರೆಸ್ಪಾಂಡೆಂಟ್. ಸಫಿಶಿಯಂಟ್ ಗೋಲ್ಡ್ ಅಂದ್ರೆ ಆಲ್ರೆಡಿ ಕೊಟ್ಟಿರೋದ ಅಥವಾ ಏನು ಈಗ ಕೊಡಕ ಅಂದ್ರೆ ಆಲ್ರೆಡಿ ಕೊಟ್ಟಿರೋದ ಅಥವಾ ಏನು ಈಗ ಕೊಡಕ ಈಗ ಏನಾರು ಟರ್ಮ್ಸ್ ಪ್ರಕಾರ ಏನಾರು ಇದೆಯೇನ್ರಿ? ಕಾಂಪ್ರಮೈಸ್ ಏನಿಲ್ಲ, ಬರೀ ಸೈನ್ ಮಾಡೋದಷ್ಟೇ. ತಗೊಳ್ಳಿ. ಎರಡಿದೆಯಾ? ಇನ್ನೊಂದೇನು? ಬೋತ್ there are two appeals. Same parties. Third, both the parties are present and respective counsels are present. Both the parties have filed memorandum of compromise petition under order 23 rule 3 of CPC. And in terms of the compromise between the parties, the respondent in RSA 1526 of 23 and appellant in RSA 1750 relinquishment deed in favor of the appellants. ಅಸ್ಬಿಟ್ರೆ ಬತ್ತೇನಿಲ್ಲ, ಬೇರೇನಿಲ್ಲ. ಇನ್ ಲಿಯೂ ಆಫ್ ಅಂತ ಬರಿಬೇಕಾ? ಇನ್ ಲಿಯೂ ಆಫ್ ಗೋಲ್ಡ್ ಕೊಟ್ಟಿದಾರ, ಕೊಡ್ಬೇಕಾ? ಆಲ್ರೆಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇನ್ ಲಿಯೂ ಆಫ್ 100 grams gold already given in favor of the respondent and appellant. Respondent in RSA 1526 of 23 and RSA 1750 of 2022. And accept these terms. There are no other grounds. And hence, and parties are also accepted the terms of compromise. And hence, compromise petition is taken on record. ಡಿಕ್ರಿ ಏನಾದ್ರು ಡ್ರಾ ಮಾಡ್ಬೇಕಾ? ಇದ್ರಲ್ಲಿ ಏನಾದ್ರು ಇದೆಯಾ? ಕೇಳಿದಿರಾ? ತಗೊಳ್ಳಿ. In terms of the compromise, the registry is directed to draw the decree. Signatures tawali. And accordingly, both the appeals are disposed of. In terms of the compromise, sir.
44. Prasanna Beer.
44. ಹೇಳಿ. ಅಷ್ಟೇ ಅಲ್ಲ, ಏನಾರು ಮಾತಾಡಿದ್ರ? ಇಲ್ಲ, ಏನಾಯ್ತು? ಯಾರಿಗೆ? ಅಶ್ವಥ್ ಅಂದ್ರೆ ಎರಡನೇ ಮಗನಿಗೆ. ಅಲ್ಲ, ದಟ್ ಈಸ್ ನೀವು ಹೇಳ್ತಾ ಇದ್ರಿ. ಬಟ್ ನಿಮ್ಮಿಬ್ರಲ್ಲಿ ಏನಾರು ಅರೈವಲ್ ಕನ್ಸೆನ್ಸಸ್ ಏನಾರು ಬಂತಾ? ನಾಮಿನಿ ಮಾಡಿದ್ದಾರೆ. ನಾಮಿನಿನಲ್ಲಿ ವೈಫ್ ಅಂತ ಹೇಳೋರ ಇಲ್ವಾ? ಹೇಳಿದಾರಲ್ಲ, ಆಯ್ತು. he himself has declared that she is the wife ಅಂತ. Now you cannot. ಆಯ್ತು, ನೆಕ್ಸ್ಟ್ ಏನ್ ಹೇಳಿ? Compassion appointment ಗೆ I will give direction to the employer to consider the application and those who is eligible to appoint the compassionate ground appoint ಅಂತ ಮಾಡ್ತೀನಿ ಅಷ್ಟೇ. ನಾವೇನು ಡೈರೆಕ್ಷನ್ ಕೊಡಕ್ಕಲ್ಲ, ಕನ್ಸಿಡರ್ ಅಷ್ಟೇ. ಟ್ರಯಲ್ ಕೊಟ್ಟನವರು ಮಾಡ್ಲಿ ಅಷ್ಟೇನೆ. ಈ ಕಂಪ್ಯಾಷನೇಟ್ ಗ್ರೌಂಡ್ಗೆ ಕೆಲವೊಂದು ರಿಕ್ವೈರ್ಮೆಂಟ್ ಇರುತ್ತೆ. ಆ ರಿಕ್ವೈರ್ಮೆಂಟ್ ನ ಕಂಪ್ಲೈ ಮಾಡಬೇಕು. ಅಲ್ಲಿ ಅವ್ರು ಲೆಟ್ ದೆಮ್ ಟೇಕ್ ಡಿಸಿಷನ್ ಅಷ್ಟೇ. ಏನ್ ಮ್ಯಾಂಡೇಟರಿ ಇಂಜಂಕ್ಷನ್ ಏನು? ಅಪಾಯಿಂಟ್ ಅಂತನಾ? ಅದ್ ಮಾಡಕ್ ಬರಲ್ಲ. 1 and 2 are their subordinates, officials, or any person acting under defendant number 1 and 2 are restrained by an order of permanent injunction from dispersing the death benefits. ಇದುವರೆಗೂ ಕೊಟ್ಟಿಲ್ವಾ ಡೆತ್ ಬೆನಿಫಿಟ್ಸ್ in favor of the third defendant or any person claiming under the third defendant ಅಂತ ಇದೆ. ಅದಕ್ಕೆ ನಾವೇನ್ ರಿಸ್ಟ್ರಿಕ್ಷನ್ ಮಾಡಲ್ಲ. ರಿಲೀಸ್ ದಿ ಅಮೌಂಟ್ in favor of the both the first wife and also the son and also the two children involved. So the two children involved settled law, because they are entitled in the properties of the parents antide. ಈಗಿನ ಲಾ ಸೆಟ್ಲ್ ಆಗಿರೋದಷ್ಟೇ. ಅದರಿಂದ ಈಕ್ವಲಿ 1/4 ಬರುತ್ತೆ. ಅದೇನು ಸರ್ವಿಸ್ ಬೆನಿಫಿಟ್ಸ್ ಇರುತ್ತೆ ಅದು. Compassionate appointment is concerned, I will direct the employer to consider the representations if any is filed and consider the eligibility of the person who files an application, then consider and appoint, issue a compassionate appointment. That's all. ನಾವು ನೀವು ಅವ್ರಿಗೆ ಕೊಡಿ ಇವ್ರಿಗೆ ಕೊಡಿ ನಾವು ಹೇಳಕ್ಕಲ್ಲ. ಈಗ ನಾವು law is settled, all our children and also the legitimate children, not illegitimate children now in view of the judgment. ಅದಕ್ಕೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅವ್ರು ಬಹಳ ಡಿಸ್ಕಸ್ ಮಾಡ್ತಾರೆ, ಇಲಿಜಿಟಿಮೇಟ್ ನಾವು ಅಂತ. ದಟ್ ಈಸ್ ದಿ ಲಾ ನಾವು. ಅಷ್ಟೇ ತೊಗೊಳ್ಳಿ. Heard the appellant counsel and also the counsel appearing for the respondent and today also, and this second appeal is filed against the divergent finding of the trial court and also the appellate court. OS number 178 of 2014, filed by the plaintiff claiming that she is the first wife. First wife ಅಂತ ಕೇಳಿಲ್ಲ, ಬಟ್ wife of Shivanna, only ಇಂತ wife of Shivanna, and the second plaintiff is the son of Shivanna. And her marriage was performed on 23/12/1989 with Shivanna at Sri Lingeshwara Temple, Davanagere, and in the said wedlock, second plaintiff was born. Earlier, the life of the first plaintiff and Shivanna was running smoothly, and both of them were happy. And thereafter, Shivanna started to ill-treat the first plaintiff and subjected for harassment. And hence, the first plaintiff has filed a petition against her husband for maintenance in Jagalur court. And so also the invoking of offence punishable under section 498A and 506 of IPC. And after the trial, Shivanna was convicted and sentenced to undergo imprisonment for 3 years. And he was also ordered to pay fine. Agreed by the said order of judgment of conviction, he preferred criminal appeal, in which also he was unsuccessful, but he was sentenced to undergo imprisonment for 6 months and to pay a fine of rupees 12,000. The said Shivanna filed revision petition bearing number 1509 of 2006 and came to be filed assailing the judgment in criminal appeal number 66 of 2006. In the said criminal, the elders and the family members, an application was filed to compound the offence, and Shivanna also filed an affidavit that he would look after the first plaintiff well and would lead a life with the first plaintiff. In view of the said fact, criminal revision petition was allowed on 27/7/2006 and conviction recorded against Shivanna was set aside. Similarly, Shivanna filed affidavit in the maintenance proceedings in criminal miscellaneous number 43 of 2005, and the same also came to be dismissed. After the disposal of the criminal revision petition by the Honorable High Court of Karnataka and dismissal of criminal miscellaneous petition, Shivanna did not act according to the terms of the affidavit, and on the other hand, he continued to neglect the first plaintiff and refused to maintain her. In this ground, another application under section 125 of CRPC was filed before the family court at Davanagere, and the family court ordered to pay monthly maintenance of rupees 3,000 in criminal miscellaneous number 156 of 2009. The said Shivanna also filed a petition seeking divorce under section 13(1)(a), 13(1) within bracket small 1.a small 1, and the same came to be dismissed after the contest, and he was directed to pay amount of rupees 10,000 to the first plaintiff. And the said Shivanna complied the said order. And Shivanna also admitted that first plaintiff is his wife, and similarly in evidence tendered by him in MC number 182 of 2011, he has admitted the said fact. And first wife continued to be the wife of Shivanna. And relationship of between Shivanna and first plaintiff persisted till death of Shivanna on 27/12/2013. It is contended that the said Shivanna admitted the judicial proceedings, and first plaintiff is the legally wedded wife. And similarly, he has not stated in the previous judicial proceedings that he has taken the third defendant as his wife. And there is no any material that he married the third defendant. And hence the claim made by the defendants, that says the wife and other defendants are children, other defendants are children, cannot be accepted. And the very contention that third defendant was appointed as nominee to receive the pension amount cannot be accepted, and endorsement issued by the department stating that there is a dispute with regard to the claim is not correct. It is contended that except the first plaintiff, there is no other wife of deceased Shivanna, and third defendant is no way related to the Shivanna or the first plaintiff. In pursuance of the suit summons, defendant number 1 has filed written statement, and same is adopted by defendant number 2 by filing adoption memo. The defendant number 1 and 2 have stated in their written statement by way of substantial defense that they admit the fact that Shivanna was working as mechanic. The state is married to Durgamma, who is the third defendant during his lifetime, and he nominated her for all his death benefit and certificate from family court to obtain the death benefits of deceased. The defendant number 3 entered into an appearance and filed written statement denying the plaintiff governments, and categorically denied that first plaintiff is not the wife of deceased Shivanna and second plaintiff is not his son, but contend that her marriage was performed on 23/11/1989, and in the said wedlock she gave birth to 2 children, and also contend that the said Shivanna made the third defendant as nominee for service benefits, and also executed a will in favor of defendant number 3 on 1/12/1999. And plaintiffs are not entitled to any relief as sought. Then, madam, the date marriage 1919. But in Shivanna and first plaintiff was performed on 23/11/1989 antide. 19, and her marriage was solemnized on 22/3/1990 at Jagaluru, and hence the plaintiff is not entitled for any relief. Defendant number 4 and 5 are children. Defendant number 4 and 5 also filed the written statement in the trial court, having considered both oral and documentary evidence, answered the issue number 1 as affirmative in coming to the conclusion that plaintiffs are the legally wedded wife and son respectively of the deceased Shivanna, and are the only legal heirs of deceased Shivanna. And recasted issue number 2 was answered in the negative and not accepted the case of defendant number 3 to 5. And also granted the relief of permanent injunction, but not granted the relief of mandatory injunction while answering the issue number 3 as negative. Being agreed by the said judgment, an appeal is filed in area number 33 of 2022. The appellate court, having considered the grounds urged in the appeal memo, and also the material available on record, and considering the submissions of both the counsels, formulated the points for consideration as follows. The appellate court, having reassessed the material available on record, comes to the conclusion that the finding of the trial court that plaintiffs are the legally wedded wife and son of late Shivanna is not proper and correct, and set aside the said finding. And also the finding with regard to the fact that plaintiffs are only the legal heirs of deceased Shivanna is not proper and correct. And also comes to the conclusion that defendant number 3 to 5 are not the wife and children of late Sri Shivanna, respectively, is also not proper and correct. And answered other point for consideration as negative. And comes to the conclusion that trial court comes to the conclusion that judgment and that decree of the trial court requires interference. And having considered the material on record and answering those points, appellate court, by allowing the appeal, set aside the judgment and decree of the trial court, and hence the present second appeal is filed before this court. This court, having considered the grounds which have been urged, while admitting the appeal, framed the following substantive question of law. Now the counsel appearing for the appellant would vehemently contend that the very approach of the first appellate court is erroneous, and no dispute that deceased was working as mechanic. And also a specific case of the plaintiff's public appellants that on 23/12/1989 was marriage was solemnized with deceased Shivanna, and second plaintiff is the son of deceased Shivanna, and the claim of the respondent that marriage was taking place on 22/3/1990, and in the said wedlock defendant number 4 and 5 born to Shivanna, and the said finding given by the appellate court is erroneous. The counsel would vehemently contend that when the appellants have approached the department, they have issued the endorsement in terms of Exhibit D2. Even though trial court granted the relief of declaration and decreed, and the same is erroneously reversed the finding of the trial court, the counsel would vehemently contend that even the subsequent marriage dated 22/3/1990 was not proved, and hence the trial court committed an error in reversing the same, and particularly recording the finding that defendant number 3 is the wife and defendant number 4 and 5 are the legitimate children of deceased Shivanna, ignoring the subsistence of marriage of plaintiff number 1 with deceased Shivanna, committed an error. For contra, the counsel appearing for the respondent would vehemently contend that though earlier proceedings was taken place between the first appellant and also her husband, that is criminal prosecution, as well as MC petition, and granted the maintenance, but nothing is placed on record that marriage was solemnized on 23/12/1989, and in the said wedlock, second plaintiff was born. The counsel also vehemently contend that the first appellate court rightly reconsidered the material available on record and comes to the conclusion that marriage was not proved, and also they are not the legal heirs of the said Shivanna. And the appellate court, considering both oral and documentary evidence, given proper finding, and it doesn't require any interference. Having heard the respective counsel and also the material on record, this court has to reanalyze the material available on record since there is a divergent finding. At the first instance, trial court granted the decree in favor of the plaintiff mandatory injunction, but the first appellate court reversed the same. And the trial court, having considered the material available on record, particularly considering the exhibit P10, copy of petition in MC number 182 of 2011, and also the objection statement between the Shivanna and the Paramakka, that is PW1, proceedings was taken place, and also it is not in dispute that he was convicted for the offence punishable section 498A and section 506, and a revision petition was filed against, appeal was filed against the same, and in the same was also confirmed. And also in the revision petition, dispute was compounded, and apart from that, the very Shivanna had filed a petition for divorce, and the same was dismissed. And apart from that, marriage invitation card as exhibit D10, and so also the passbook, SB passbook of Shivanna as exhibit P11 and 12, and MC number 182 of 2011 and dismissal cannot be a ground to comes to the conclusion that and in paragraph number 43 made an observation that it is clear that plaintiffs have proved that they are the wife and son of Sri Shivanna, and even the defendant number 3 to 5 have proved that they are the wife and children of Sri Shivanna. Whereas the plaintiff's number 1 wedding with the said Sri Shivanna was solemnized on 23/12/1989. The marriage of said Shivanna with defendant number 3 was solemnized on 22/3/1990. This goes to show that plaintiff's number 1 marriage with Sri Shivanna solemnized prior to the marriage of Sri Shivanna with defendant number 3. Now that it is clear that defendant number 3 is the second wife of Shivanna, who married again during the subsistence of marriage with plaintiff number 1, and defendant number 4 and 5 are the children born to him. Now and children. In paragraph number 47 made an observation that issue number 1 and 2 are partly affirmative, thereby holding that plaintiffs and defendant number 1, defendant number 3 to 5 are the legal heirs of Shivanna. And further observation is made that it is incumbent upon this court to point out that the plaintiffs have filed the suit seeking declaration to the effect that they are the only legal heirs of deceased Shivanna. But before issuing such declaration, this court must foresee the consequences of the same. It is also observed that it must be understood that the declaration to the effect the plaintiff or the legal heirs of Sri Shivanna is entirely different from seeking the declaration to the effect that plaintiffs are only legal heirs. And where this court has held that even the defendant number 4 and 5 are the legal heirs, dismissing the suit is not correct and it requires interference. making such an observations by the appellate court, comes to the conclusion that judgment requires to be set aside. Having read the judgment of the trial court as well as the first appellate court, and first appellate court also agrees with regard to the fact that plaintiff is the wife of Shivanna, and also the second plaintiff as the son of Shivanna through the Barmakka, and also comes to the conclusion that defendant number 3 to 5 is also this wife and 2 children, and they are also the legal heirs. But the fact is that when the marriage was solemnized earlier, and subsequent marriage was also solemnized with the Shivanna, the second wife will not get any benefit since the very marriage itself is void to their parents. Such law is settled, and having considered the material on record, now the second wife is no more, and only first wife and his son and also her son, and also the defendant number 4 and 5, who are the children born to a second wife, are alive. And when such being the case, in view of law is settled under section 16, as well as the apex court also made it clear that irrespective of the children born to the first wife and second wife, and they can be treated as legitimate children, and there cannot be any stigma to the children born to the second wife. And when such being the case, the plaintiff number 1 and 2, and also the defendant number 4 and 5 are the legal heirs of deceased T. Shivanna, and in view of the same, they are entitled for share in the property of the Shivanna, that is in the separate property of Shivanna, and only the plaintiff number 1 and 2 are entitled for share in, if any, ancestral properties. But defendant number 4 and 5 are entitled for a share in the property of separate property of Shivanna, and hence clarified the same by this court. The trial court committed an error. Defendant number 3 is the wife, and defendant number 4 and 5 are the legitimate children of deceased Shivanna, but ought not to have declared defendant number 3 is the wife, when since legal wife, since the marriage was taken place when the first marriage was subsisting, but defendant number 4 and 5 are the legitimate children in view of the law evolved in view of section 16 as well as judgment of the apex court. But dismissal of the suit of the plaintiff by the trial court is erroneous, ignoring the subsistence of marriage of plaintiff number 1 with the Shivanna, and hence judgment and decree of the trial court requires to be set aside by modifying the same. Trial court on appellate court, trial court on appellate court in RA 178 of 2014, and the same requires to be modified, declaring that 170, sorry, 33 of 22, and judgment and decree of the trial court also requires to be modified OS number 178 of 2014, that plaintiffs as well as defendant number 4 and 5 are the legal heirs of the deceased T. Shivanna. Now with regard to the claim made by them before the employer to appoint the first defendant as first defendant on the ground of compassionate ground. RSA is disposed of. ಹೇಳಿ ಏನ್ 4 and 5 ಏನ್ ಎಸ್ ಶಿವಪ್ಪ ನಾನೇನು ಹೆಸರೇನು ಯಾರು ನಾನು ಯಾರಿಗೂ ಹೆಸರೇನು ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ. ಡಿಫೆಂಡ್ ನಂಬರ್ 4 and 5. Defend number 4 and 5 and plaintiff 1 and 2 are the legal heirs of T. Shivanna. ಅಷ್ಟೇ. ಎಸ್ ಶಿವಣ್ಣ ಅಷ್ಟೇ. ಎಸ್ ಶಿವಣ್ಣ ಅವರು ನಾನು ಈ ಅನ್ನ ಹೆಸರಲ್ಲಿ ಏನಿದೆ ಒಂದು ಯಾಗಾರೆ ಎಸ್ ಶಿವಣ್ಣ ಅಂತ ಹಾಕೋಬಿಟ್ರಿ ಮೇಡಮ್. ಶಿವಣ್ಣ ಒಟ್ನಲ್ಲಿ ಶಿವಣ್ಣ ಅಷ್ಟೇ. Any applications are filed, consider in a
That is not their case. I am the first wife. That is not their case. Even in observing by the Arya minors, they have stated wife and children minors, not the second wife. Only wife and children. Here, it is a clever drafting done by the High Court Council minors. Here, whatever documents that we have produced so as to prove our marriage minors, clearly.
ನಾನು ಯಾರನ್ನು ಈಗ ಫಸ್ಟ್ ವೈಫ್ ಸೆಕೆಂಡ್ ವೈಫ್ ಅಂತ ಡಿಕ್ಲೇರ್ ಮಾಡಿಲ್ಲ. ಕ್ಲೈಮ್ ಮೇಡ್ ಬೈ ದೆಮ್ ಥ್ರೂ ವೈಫ್ ಅಂತ ಹಾಗೆ ಹಾಕೋಬಿಟ್ರಿ ಮೇಡಮ್ ವೈಫ್ ಅಂತ. ಆಯ್ತು. ಯಾವ್ದು ಇನ್ನೊಂದು ಯಾವ್ದೋ ಒಂದು ನೆನ್ನೆ ಯಾವ್ದು ಹಾಕೊಂಡ್ವಲ್ಲ ಅದು ಯಾವ್ದು ಏನಾಯ್ತಲ್ಲ
ಲಿಸ್ಟ್ 3
ಇನ್ನೊಂದು ಯಾವ್ದೋ ಪಾಠ ಆಡಿರ್ಬೇಕು ನೋಡಿ. ಇವತ್ತೆಲ್ಲ ಅಡ್ಮಿಷನ್ ಏನೋ ಡೌಟ್. ಅಡ್ಮಿಷನ್ ಫೈನಲ್ ಇಯರಿಂಗು ಎಲ್ಲ ಡೌಟೆ ನೋಡೋಣ. ಇವತ್ತೆಲ್ಲ ಅಡ್ಮಿಷನ್ ಏನೋ ಡೌಟ್. ಅಡ್ಮಿಷನ್ ಫೈನಲ್ ಇಯರಿಂಗು ಎಲ್ಲ ಡೌಟೆ ನೋಡೋಣ. ಇವ್ರೇನಾರು ಬೇಗ ಮುಗಿಸ್ತಾರೆ. ನೆನ್ನೆ ಇತ್ತಲ್ರಿ, ನೆನ್ನೆಯಿಂದ ಇವತ್ತು ಹಾಕೊಂಡ್ವಲ್ಲ ಅದೇ ಅಲ್ಲ. ಅರ್ಧ ಡಿಕ್ಟೇಷನ್ ಆಗಿತ್ತು. ಅರ್ಧ ಡಿಕ್ಟೇಷನ್ ಹಾಕಿದ್ದು. ಏನು ನೀವ್ ಯಾರೋ ಒಬ್ರು ಒಕ್ಕಲತ್ ಹಾಕಿದಿರಲ್ಲ 3A. ಏನ್ ರೆಡಿ ಇದೀರಾ ಇಲ್ಲ? ಎಲ್ಲೋದ್ರು ಅವ್ರು ಮತ್ತೆ ಇಲ್ವಾ ಮೇಡಮ್? ಅಲ್ಲ ರೀ ಲಾಸ್ಟ್ ಟೈಮ್ ಟೈಮ್ ಕೇಳಿದಾರೆ. ಕೊಡಿ ಮೇಡಮ್. ಮೆಮೊ ಮಾಡಿದಾರ ನೀವ? ನಾಟ್ ರೆಡಿ. ಅಪೀಲ್ ಆಫ್ ದಿ 21 ಕೋರ್ಟ್ ಫೀ ಕೊಟ್ರು ಲಾಸ್ಟ್ ಟೈಮ್ ಒನ್ ಅಕೇಶನ್ ತಗೊಳ್ಳಿ. ಪ್ರಾಕ್ಸಿ ಕೌನ್ಸಿಲ್ seeks time on the ground that appellant counsel is not well and counsel for the respondent objects for adjournment on the ground that 1 year back also sought time and in view of submission of not keeping well 2 weeks time granted, list this matter on ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ಕೊಡಿ. 7/8 ಪಾಠಾಡನ್ನ ಮಾಡಕ್ಕಲ್ರಿ ಯಾಕೆ ನಾಡಿದ್ಗೆಲ್ಲ ಆಗೋದಿಲ್ಲ ಇವ್ರೆ. ಈಗ ಇರೋದ್ ಮಾಡಕ್ಕೆ 20 ಇದಾವೆ ಪಾಠಾಡ್. ಅದ್ರಲ್ಲಿ ಎಷ್ಟು ರಿಲೀಸ್ ಮಾಡ್ಬೇಕು ಅಂತ ನಾನೇ ನೋಡ್ತಾ ಇದ್ದೀನಿ. ಯಾವ್ದು ಮಾಡಕ್ಕಾಗುತ್ತೋ ಫ್ರೈಡೇ ವರೆಗೆ ಮಾಡ್ತೀನಿ, ಬಾಕಿದೆಲ್ಲ ರಿಲೀಸ್ ಮಾಡೋಗ್ತೀನಿ ಅಷ್ಟೇ. ನಡ್ಸಲ್ ಯಾಕೆ ನಾನು ಆವಾಗಿನ 3 ವಾರದಿಂದ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಪಾರ್ಟ್ ಹಾರ್ಡ್ಗೆ ಅಸಿಸ್ಟ್ ಮಾಡಿ ಅಂತ. ಕೌನ್ಸಿಲ್ಸ್ ಯಾರು ಅಸಿಸ್ಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ. ಆಯ್ತು, ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 7/8. ಇವನ್ ಅದೇನೆ ಇವತ್ತು ಫಸ್ಟ್ ಹಾಕೊಳ್ಳೋ ಹೊತ್ತಿಗೆನೆ ಇವತ್ತು ಈಗೆಲ್ಲ ಪಾರ್ಟ್ ಹಾರ್ಡ್ ಎಲ್ಲ ಡಿಸ್ಪೋಸ್ ಮಾಡಕ್ ಆಗ್ತಾ ಇದೆ. ಇಲ್ಲಾಂದ್ರೆ ಅಡ್ಮಿಷನ್ಸ್ಗಿಂತ ನಂತರ ಹಾಕಿರ ಅವು ಆಗ್ತಿರ್ಲಿಲ್ಲ. 46 ಯಾರು ಹೇಳಿ? 7/8 ಹೇಳ್ರಿ. ರಿಟರ್ನ್ ಅಡ್ವಾನ್ಸ್ ಅಮೌಂಟ್ ಆಫ್ rupees 1,50,000. Trial court comes to the conclusion that there was a sale agreement, but ordered to refund of amount with 18% interest. Now the appellate court comes to the conclusion that ought to have granted the relief of specific performance. Cross appeal ಹಾಕಿದಿರಾ ನೀವು? ಏನ್ ಕ್ರಾಸ್ ಅಪೀಲ್? ಕ್ರಾಸ್ ಅಪೀಲ್ ಕೋರ್ಟ್ ಫೀ ಕಟ್ಟಿದಿರಾ? ಕ್ರಾಸ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಎಲ್ಲಿದೆ ನಿಮ್ಮ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್ ತೋರಿಸಿ. ಇನ್ ದಿ ಅಪೀಲ್ ಪಾಯಿಂಟ್ ಫಾರ್ ಕನ್ಸಿಡರೇಷನ್ ರೈಸ್ ಆಗಿದೆಯಾ ಇನ್ ಅಪೀಲ್ ಅಲ್ಲಿ? ಕ್ರಾಸ್ ಅಪೀಲ್ಗೆ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ನೀವು ಕೋರ್ಟ್ ಫೀ ಕೊಡ್ಬೇಕು. ಕೊಟ್ಟಿದ್ದೀರಾ? ಕ್ರಾಸ್ ಅಪೀಲ್ ಅಲ್ಲಿ ನೀವು ಕಟ್ಟಿದ್ದೀರಾ ಅನ್ನೋ ಪ್ರಶ್ನೆ. ನನಗೆ ಅಬ್ಸರ್ವೇಷನ್ ಬಿಟ್ಬಿಡಿ. ನೀವು ಕ್ರಾಸ್ ಅಪೀಲ್ ಹಾಕಿದ್ರಲ್ಲ, ಕೋರ್ಟ್ ಫೀ ಕಟ್ರೆ ಮಾತ್ರ ಕ್ರಾಸ್ ಅಪೀಲ್ ಬರೋದು. ಬಟ್ ಯು ಪ್ಲೇಸ್ ದಿ ರೆಕಾರ್ಡ್. ನಿಮ್ ಕ್ರಾಸ್ ಅಪೀಲ್ ಇತ್ತು, ನಾನು ಕೋರ್ಟ್ ಫೀ ಕೊಟ್ಟಿದ್ದೆ ಇನ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಅಂತ ತೋರಿಸಿ. ದೆನ್ ವಿಲ್ ಕನ್ಸಿಡರ್ ಇಟ್. ತಗೊಳ್ಳಿ. ಯಾವ್ದ್ರಲ್ಲಿ? ಕ್ರಾಸ್ ಅಪೀಲ್ ಅದ್ರಲ್ಲೇ ಹಾಕಿರ್ತಾರ್ರಿ ನೋಟಿಸ್. ಏನಲ್ಲ ನಿಮ್ಗೊಂದು ಕಾಪಿ ಕೊಡ್ಬೇಕು ಅವರು. ಅದ್ರ ಕ್ರಾಸ್ ಅಪೀಲ್ ಕಾಪಿ ಕೊಟ್ಟಿದಾರಾ ಇಲ್ಲ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ. ಇಲ್ಲೂ ಇಲ್ಲ. ಇಲ್ಲಿ ಪಾಯಿಂಟ್ ಫಾರ್ ಕ್ರಾಸ್ ಅಪೀಲ್ ಹಾಕಿದ್ದೀರಾ? ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದೀರಾ ಅವರಿಗೆ ಅದರ್ ಸೈಡ್ಗೆ? ಮಾಡಿದ್ರೆ ಸರಿ. ಬಟ್ ಇದೆಯಾ ಅಂತ ಕೇಳಿದ್ ನಾನು. RA 128 of 2018 ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದ್ರಲ್ರಿ. 22 Rule 2 ಇದರಲ್ಲಿ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿನೇ ಇದೆ. ನೀವಿಲ್ಲ ಅಂತೀರಿ. ನೀವು ಫಸ್ಟ್ ವೆರಿಫೈ ಮಾಡಿ. ಕ್ರಾಸ್ ಅಪೀಲ್ ಕೋರ್ಟ್ ಫೀ ಕೊಡ್ಬೇಕು, ಕೊಟ್ಟಿದ್ದೀರಾ ಅಂತ. 3 as affirmative by the honorable court and hold the issue number 3 as negative ಅಂತ ಕೇಳಿದಿರಿ. ಆಯ್ತ್ರಿ. ಅವ್ರ ಕೇಸ್ ಏನು ಅಂದ್ರೆ ಈಗ ಅಪೀಲ್ ಅಲ್ಲಿ, ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದೆ, ದಟ್ ಹ್ಯಾಸ್ ನಾಟ್ ಬೀನ್ ಕನ್ಸಿಡರ್ಡ್ ಅಂತ. ಅದಕ್ಕೆ ನಾನು ಅವ್ರಿಗೆ ಅದನ್ನೇ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಅವ್ರ ಟೈಮ್ ಕೇಳ್ತಾ ಇದಾರೆ. Appellant counsel seeks time to place on record for having paid the court fee on the cross objection. Cross appeal filed by him and hence this matter on 7/8. ಕೊಡಿ ಅವರು. ಆಯ್ತು. 8/8 8/8 ರಜಾ ಅಂತ್ರಿ. 7/8 ಫ್ರೈಡೆ ಬರುತ್ತೆ. 7/8 ಬೇಕು. 6/8 ಬೇಕಾ? ಆಯ್ತು. 6/8 ಇದ್ರಲ್ಲಿ ಇನ್ಯಾರು ಇದಾರ? ನೋಟಿಸ್ ಟು R2 and R3 ಡಿಸ್ಪೆನ್ಸ್ಡ್ ವಿತ್. ಆಯ್ತು. ನೆಕ್ಸ್ಟ್
47 P. Nataraj 17 share in respect of item number 1. ಈಗ ಎಂಟೈರ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಹೇಳಿ. ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಾ? ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಗ್ರಾಂಟೆಡ್ ಅರ್ಲಿಯರ್ ಇಸ್ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಟಿಲ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್. ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆಯಾ? ಅದರ್ ಸೈಡ್ ನೋಟಿಸ್ ಹೋಗಿದೆಯಾ?
ನೋಟಿಸ್ ಹೋಗಿದೆ ಸ್ವಾಮಿ.
ಸರ್ವ್ ಆಗಿದೆ.
ಸರ್ವ್ ಆಗಿದೆ. ಯಾರು ಅನ್ರೆಪ್ರೆಸೆಂಟೆಡ್. ಡೈವರ್ಜೆಂಟ್ ಫೈಂಡಿಂಗ್.
ಸಬ್ಸ್ಟಾಂಟಿವ್ ಕ್ವೆಶ್ಚನ್ ಆಫ್ ಲಾ ಫ್ರೇಮ್ ಆಯ್ತಾ? ಇಲ್ಲ
ಆಗಿಲ್ಲ.
ಕೊಡಿ.
FTP ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್.
Heard the appellant counsel and this court also issued notice against the respondents and all of them have been served and unrepresented. The main contention of the counsel appearing for the appellant that trial court granted only share in respect of item number 1, granting 17 share. ನೀವು ಈಗ ಎರಡು ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಹೌದು ಸ್ವಾಮಿ.
And appellate court reversed the said finding, granting relief in
ಸ್ವಾಮಿ ಫಸ್ಟ್ ಅಪೀಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆಗಿರೋದು ಮಾತ್ರ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾರೆ. ಯಾಕಂದ್ರೆ ಐಟಮ್ ನಂಬರ್ 1 ಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ನಾವೇನು ಚಾಲೆಂಜ್ ಮಾಡ್ತೀವಿ.
And hence the plaintiffs have filed an appeal in RA 17 of 2019 and appellate court reversed the finding and granted share in remaining properties also, and hence the second appeal is filed before this court. The main contention of the counsel before this court is that appellate court committed an error in granting the share in all the properties and finding given by the first appellate court on issue number 1 and 5 is not just and proper. And also counsel would contend that first appellate court fails to take note of the fact that there was already a partition in respect of the suitable properties as per exhibit D1 and same was acted upon, and already there was a severance of the joint family status. Question of granting the relief of partition doesn't arise and committed an error in granting share in item number 2 to 7. Having heard the appellant counsel, And also considering that there is a divergent pending and the trial court only granted relief in respect of item number 1 and remaining properties are concerned, not granted the relief. And now there is a divergent pending and matter requires reconsideration. Admit. The following substantive question of law arises for the consideration of this court. Whether the first appellate court committed an error in answering issue number 1 and 5 that the plaintiffs are entitled for share in all the scheduled properties, considering the suit scheduled properties are ancestral and undivided joint Hindu family property. Whether the first appellate court committed an error in coming to the conclusion that the defendants have not proved the family partition took place during the lifetime of the parents, that is in the year 2001. ಅಷ್ಟೇ ಎರಡೇ ಬರೋದು.
Stay application.
Heard on IA number 1 of 24 wherein prayer is sought to stay the FDP proceedings
32 of 2022.
in FDP number
32 of 2022.
32 of 2022. And having considered the divergent finding and hunting of share in respect of all the shares, trial court is directed not to draw the final decree till the next date of hearing. Issue notice against the respondent in the meanwhile. ಆಗಿದೆ. Records ಬಂದಿದೆ. List the matter for final hearing in the 3rd week of August.
Apply.
Filing of paper book is dispensed since the lower court records are received. Next. 48.
The Lordship would like to file memo of withdrawal.
Withdrawal. Kodi. Appellant counsel files memo seeking permission of this court to withdraw the appeal on the ground that matter is likely to be settled among the family members, and in view of the reasons assigned in the memo permitted to withdraw. 49. Manjunatha G.
Appearing for appellant in this case, my lord. Last time the respondent counsel came and asked for time to file the LRs, but till now they have not filed. We had filed in submission saying that respondent number 1 has died and there is no LRs, and we had even filed a memo with his death date.
ಯಾಕೆ ಇಲ್ಲಿ ಬರ್ತಾ ಇಲ್ಲ ಮೇಡಮ್?
So last time the respondent counsel asked for time to file the LRs on record, though we had submitted that there is no LRs.
The respondent number 1 who has
Sorry,
passed away.
counsel appearing to the respondent files memo along with Aadhaar card of one Srimati Manjula. She is claiming to be the
Wife of the respondent number 1.
wife of the respondent number 1. ಆಯ್ತು, ಅವ್ರು ಹಾಕಿದ್ದಾರೆ ನೋಡಿ, ವೆರಿಫೈ ಮಾಡಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಳ್ಳಿ ನೀವು ಅಷ್ಟೇ.
Much obliged. A date can be given in the 1st week of August, my lord.
Counsel seeks 2 weeks time to bring to file list this matter on 7/8.
My lord, 7th I am not there. 6th if it can be.
ಆಯ್ತು, 6/8.
Much obliged, your lord.
Much obliged. my lord.
50.
ಎಲ್ಲರೂ 7th 8th ರಜಾ ಕೊಟ್ಟಿರ ತಕ್ಷಣ 7th ಸೇರ್ಸ್ಕೊಂಡು ಹೋಗ್ಬಿಡ್ತೀವಿ ಅಂತ. 50 ಹೇಳ್ರಿ ನಾಗರಾಜು
BS ನಾಗರಾಜ್.
ಹೋಗ್ಬಿಡ್ತೀವಿ ಅಂತ. 50 ಹೇಳ್ರಿ ನಾಗರಾಜು.
BS ನಾಗರಾಜ್.
The defendant's 9th appeal. So the suit for partition and separate position. The trial court decreed the suit for 184 share to the plaintiff.
ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆಯಾ?
ಇಲ್ಲ sir. Records.
ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿಲ್ಲ.
Scheduled properties. Appeal now is confined to.
No, it is not confined to. If such is the case, my lord, the suit itself is not maintainable.
ಆಯ್ತ್ರಿ, ಈಗ ಮಾಡಿಫೈ ಆಗಿದೆ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಹೌದು.
ರೆಕಾರ್ಡ್ಸ್ ಬೇಕಾಗ್ತದೆ. ರೆಕಾರ್ಡ್ಸ್ ತರ್ಸನ then we can decide.
Trial court decreed
ಮಾಡಿದ್ದಾರೆ 184 ಶೇರ್ ಅಂತ ಕೊಟ್ಟು ಅಪಾರ್ಟ್ ಫ್ರಮ್ ಮೇಂಟೆನೆನ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ.
But so far as degree of the goods lot, that portion is concerned, he has not filed appeal. Rejection of the remaining portion lot, the plaintiff has filed appeal.
That is modified in the appeal.
So far as only in respect of 2 items lot, it is modified. Now during pendency of the appeal lot, the appellate has sold all the properties.
Already sold.
No, is not sold all the properties. Item number 9 and 10 is sold. In respect of the other properties, my share is there in dependent number 9. And moreover, the plaintiffs are not examined, are not entered into.
51.
ಇನ್ನು ಯಾರು ಇದಾರ? 1 to 8 ಅಷ್ಟೇನಾ ಇರೋದು ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್? ಇನ್ನು ಯಾರು ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾ ನೋಡಿ? ಬೇರೆಯವ್ರಿಗೆಲ್ಲ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾ? ಡಿಸ್ಪೆನ್ಸ್ ಕೇಳ್ತೀರಾ? ವೆದರ್ ದೇ ಹ್ಯಾವ್ ಕಂಟೆಸ್ಟೆಡ್? 22 ಜನ ಇದ್ದಾರೆ. ಅದ್ರ ಕಂಟೆಸ್ಟ್ ಮಾಡಿದಾರ ನೋಡಿ, ಯಾರು ನೋಡಿ.
So far as suit is concerned, it was decreed in part. In respect of 2 items, dismissed. Against the dismissal of 2 items, not I filed a plaintiff filed appeal. He has not filed any appeal. Therefore, not
That is modified.
in respect of only 2 items, in respect of only 2 items, not it is modified.
ಆಯ್ತು, ಅಪೀಲ್ ಅಲ್ಲಿ ಯಾರು ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿರೋ ಅವ್ರಿಗೆ ಕೊಡ್ಬೇಕಲ್ಲ ನೋಟಿಸ್. ಅವ್ರು ಯಾರು? ನಿಮ್ಮ ಅಪೀಲ್ ಅಲ್ಲಿ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿದವ್ರು ಯಾರು? ಅವ್ರಿಗೆ ಕೊಡ್ಬೇಕಲ್ಲ ನೋಟಿಸ್. ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಪೀಲ್ ಅಲ್ಲಿ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿದವ್ರಿಗೆ. ಆಯ್ತು, ಡಿಫೆಂಡೆಂಟ್ಸ್ ಯಾರು ಕಂಟೆಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಅಪ್ಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಕೊಡ್ಬೇಕಾಗುತ್ತೆ. ಯಾರ್ಯಾರು ನೋಡಿದ್ರೇನ್ರಿ?
ಎಲ್ಲರೂ ಮಾಡಿದ್ದಾರೆ ಸರ್.
ಎಲ್ಲರೂ ಕಂಟೆಸ್ಟ್ ಮಾಡಿದಾರ?
ಅವರು ಇನ್ನು ಉಳಿದವರು ಸೆಪರೇಟ್ ಅಪೀಲ್ ಹಾಕಿದ್ರು, ಡಿಸ್ಮಿಸ್ ಫಾರ್ ಡಿಫಾಲ್ಟ್ ಆಯ್ತು.
ಅವರು ಅಪೀಲ್ ಹಾಕಿದ್ರು,
ಅಪೀಲ್ ಹಾಕಿದ್ರು, ಡಿಸ್ಮಿಸ್ ಫಾರ್ ಡಿಫಾಲ್ಟ್ ಆಯ್ತು. ಅವ್ರು ಕಂಟೆಸ್ಟ್ ಮಾಡಿಲ್ಲ, ಕಂಟೆಸ್ಟ್ ಮಾಡಿದ್ದು ಇವ್ರು ಒಬ್ರೇ.
ನೋಡಿ ಹೆಂಗಾರ ಕಂಟೆಸ್ಟ್ ಮಾಡಿದವ್ರು ಇವ್ರೊಬ್ರೆ ಅಂತಾರೆ, ಬೇರೆಯವ್ರು ಏನು ಮಾಡಿಲ್ಲ ಅಂತ. ಆರ್ಎ ಜಜ್ಮೆಂಟ್ ಕೊಡಿ. R8 ವರೆಗೂ ಇವರೇನೆ. ಹೌದು, ಆರ್ಎನಲ್ಲಿ ಯಾರು ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿದಾರೆ ನೋಡ್ರಿ ಗೊತ್ತಾಗುತ್ತೆ ಫಸ್ಟ್. ಹಾ,
RA 73 ಒಂದಿದೆ, RA 79 ಒಂದಿದೆ.
70 ಆಗಿ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿದ್ರು ನೋಡೋಣ.
73 ಅಲ್ಲಿ ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 2 and his brothers filed RA 73. That was dismissed for default. Then RA 79 not filed by wife of defendant number 9. That was also dismissed. Now this appeal.
R1A and B are expert.
Yes.
R2, R5 to 9, R13 to 15 are absent. ಅವ್ರಿಗೆ ಬೇಕಾ ಇಲ್ಲ, ಅವ್ರು ಯಾರು? And R17 and 18 also dismissed. ಅವರೆಲ್ಲ ಬೇಕಾ ಇಲ್ಲ. ಯಾಕೆ ಬೇಕು? ಡಿಸ್ಮಿಸ್ ಆದವರು, ಎಕ್ಸ್ಪರ್ಟ್ ಆದವರು, ಆಬ್ಸೆಂಟ್ ಆದವ್ರಿಗೆಲ್ಲ ಬೇಕಾ ಇಲ್ಲ. ಈಗ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 3 and 4 ನೀವ್ ಯಾರಿಗೆ ಅಪಿಯರ್ ಆಗೋದು? ಅಪೀಲ್ ಅಲ್ಲಿ R3 and 4 ನೀವು ಸೌಜನ್ಯಾಗ ನೀವು ಅಪೀಲ್ D9.
That is 9C to 9E.
ಇಲ್ಲಿ ಯಾವ್ದು ಅಪೀಲ್ ಅಲ್ಲಿ ಯಾರು ಇಲ್ವಲ್ಲ 9C ಅಂತ. ನೀವು ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡೋದು ಯಾರಿಗ್ರಿ? R9 ಸಾಗರ್ಗ. 10 to 12 CR ಸಮೃದ್ಧ.
ಅಲ್ಲ, ತಾವು OS ಜಜ್ಮೆಂಟ್ ತಾವು ಒಂದ್ಸಲ ನೋಡ್ಬಿಟ್ಟು D9 ಸತ್ತೋಗ್ತಾರೆ, ಅವ್ರಿಗೆ ಎಲ್ಲಾರ್ಸ್ ಆಗಿ D9A to 9E ಬರ್ತಾರೆ. 9A and B is concerned blood, they filed separate appeal, that was dismissed for default. Now 9C to 9E
ನಮಗೆ ಬೇಕಾ ಇಲ್ಲ. ಈ ಆರ್ಎನಲ್ಲಿ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿರೋದು ಓನ್ಲಿ
9C to 9E.
R3 and 4 ಆಯ್ತಾ? R3 and 4 ಅಂದ್ರೆ ಯಾರು ಅಂದ್ರೆ ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾಗುತ್ತೆ. ಸೌಜನ್ಯ ಎಂತದ್ದು ಮನ್ವಿಕ್ ಗೌಡ ಇವ್ರಿಬ್ರಿಗೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು, ಅವ್ರು ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿದ್ದಾರೆ. ಅವ್ರು ಬಿಟ್ರೆ ಇವ್ರ ಪ್ರಕಾರ 10 to 12 ಈಗ ಅವ್ರು ಅಪಿಯರ್ ಆಗ್ತಾ ಇದ್ದಾರೆ, ಅವ್ರದೇ ಅಪೀಲು 10 to 12. ಆಮೇಲೆ 16 ಒಬ್ರು ಇದ್ದಾರೆ, R16 ಯಾರು ಅಂದ್ರೆ ಸುರೇಶ್ ಅಂತ ಒಬ್ರು ಇದ್ದಾರೆ.
ಅವರು ಲೆಸ್ಸಿ ಆಫ್ ದಿ ಸೂಟ್ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ, ಈಸ್ ನಾಟ್ ಎನ್ LR.
ಅವ್ರು ಬೇಕಾಗಿಲ್ಲ,
ಅವ್ರು ಬೇಕಿಲ್ಲ.
ಆಯ್ತು, ಇನ್ ಬಾಕಿಯವ್ರು ಯಾರು ರೆಪ್ರೆಸೆಂಟೇ ಮಾಡಿಲ್ಲ ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಷ್ಟೇ. R10 to 12 ಆಯ್ತು. 3 and 4 ಇದ್ದಾರೆ. 3 and 4 ಇಲ್ಲಿ ಸೌಜನ್ಯ ಎಷ್ಟನವ್ರಿ ಇದ್ರಲ್ಲಿ? ಕೆಂಪಮ್ಮ, ಯಶೋದಮ್ಮ, ಲಕ್ಷ್ಮಮ್ಮ.
My lord, Saujanya along with D2, my lord, filed separate appeal. That was also dismissed. RA 73 was filed by them.
ಆಯ್ತು ರೀ, ಡಿಸ್ಮಿಸ್ ಆಯ್ತು ಅವ್ರ ಅಪೀಲು. ಬಟ್ ನಿಮ್ಮ ಅಪೀಲ್ ಅಲ್ಲಿ ಅವ್ರು ಕಂಟೆಸ್ಟ್ ಮಾಡಿದಾರಲ್ಲ R12.
ಇಲ್ಲ, ಇಲ್ಲಿ
12 and 13 ಮೇಡಮ್ ತೋಳಿ. ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಗೇನೆಸ್ಟ್ R12 and 13 ಅಷ್ಟೇ. ನೋಟಿಸ್ ಹೋಗ್ಲಿ. ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಗೇನೆಸ್ಟ್ R12 and 13. ಮೆಮೊ ಹಾಕ್ಬೇಕು, ನೀವು ಬೇರ್ಕೊಂಡು ಮೆಮೊ ಹಾಕಿ. ಈಗಲೇ ಹಾಕ್ಬೇಕು. ನೆಕ್ಸ್ಟ್
T1.
ಕೆ ವಸಂತ್. ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ AG6 ಟೈಮ್ ಅಂತ ಏನೋ ಇತ್ತು ಖಾತಾ.
ಅವ್ರು ಇರ್ಲಿಲ್ಲ, ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ರು.
ಹಾ,
The objection filed to the appeal, not to the application filed by me.
1/23 ಫಾರ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಫ್ ಪ್ಲೇಂಟ್ ಇದೆ.
ಅದಕ್ಕೆ ಅವ್ರು they have not filed any objection.
ಯಾರು ಹಾಕಿದಾರ ಅಲಾಂಗ್ ವಿತ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಂತ
That
ಇದೆ.
is objection is to the main petition, main appeal.
ಮೇನ್ ಅಪೀಲ್
My lord, it is by oversight.
ಏನ್ ಹೇಳಿ, ಏನ್ ಓವರ್ಸೈಟ್?
We have filed statement of objections, my lords. So,
AGF for R1 to R4 ಅಂತಿದೆ. ಹೇಳಿ.
my lord, I have to take instructions, my lords.
ಲಾಸ್ಟ್ ಟೈಮ್ ಆಲ್ಸೋ ಯು ಸಾಟ್ ಟೈಮ್ ಮೇಡಮ್.
ಇಲ್ಲ, my lords.
ನೋಡಿ, ಹಿಂದಿನ ಸರ್ಲು ಕೂಡ ಅದೇನೆ. ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ ಮೇಡಮ್. ಇಲ್ಲಿ ಯಾವ್ದೋ ಒಂದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಂತ ಇದೆಯಲ್ಲ, ಯಾವ್ದಕ್ಕೆ? ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ ಮೇಡಮ್. ಇಲ್ಲಿ ಯಾವ್ದೋ ಒಂದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಂತ ಇದೆಯಲ್ಲ, ಯಾವ್ದಕ್ಕೆ?
ಅದು ಅಪೀಲ್ಗೆ ಹಾಕಿದ್ದಾರೆ.
Appeal ಗೆ ಬರೋದಿಲ್ಲ, my lord.
ಅಪೀಲ್ಗೆ ಹಾಕಿದಾರ.
ಅಯ್ಯಾಗ ಹಾಕಿದ್ರು.
But by oversight.
RS ಏನ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ತೀರಿ ಮೇಡಮ್?
ಇಲ್ಲ, my lords, ಅದು ಐಎಗ್ ಹಾಕೋ ಬರ್ಲಿ.
ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಫೈಲ್ಡ್ ಆನ್ ಬಿಹಾಫ್ ಆಫ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 to 4 ಅಂತಿದೆ. ಅಮೆಂಡ್ಮೆಂಟ್ ಗೆ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕ್ಬೇಕು. ಏನ್ ಹಾಕಿದಾರೆ ಈಗ?
ಅದು ಪ್ಯಾರಾಗ್ರಾಫ್ಸ್ ಅದು ಬಂದು
ಎಲ್ಲ ಅಪೀಲ್ಗೆ ಹಾಕಿರೋದಾ?
ಅಪೀಲ್ಗೆ ಹಾಕಿದ್ರು.
ಹಾ,
ಫ್ಯಾಕ್ಟ್ಸ್ ಎಲ್ಲ ಹೇಳಿ
ನೀವೇನು
ಅಪೀಲ್ ಇಸ್ ನಾಟ್ ಮೇಂಟೈನ್.
It is filed for amendment of plaint.
ಹೌದು, ಅದಕ್ಕೆ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿಲ್ಲ.
That, but by oversight appeal ಹಾಕ್ಬಿಟ್ಟಿದೆ.
ನೋಡಿ, HCGP ನಾ ನೀವು?
Please, my lord.
HCGP 6 time to file objections to IA number 1/23 wherein prayer is sought for amendment of plaint and finally granted 2 weeks time. If objections not filed to IA within 2 weeks and the same will be taken as not filed in the next date of hearing. List this matter on 7/8. ಬರ್ಕೊಳ್ಳಿ, ಅದನ್ನ ಮಾಡಿ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ಗೆ.
Please, my lords.
52 ನಂದೀಶ್ ಗೌಡ GB ಹೇಳ್ರಿ. Suit for partition dismissed
decree of the trial court.
on the ground of paternity only.
Paternity only. Second appeal has been filed before this honorable court at the first instance.
Paternity ಬಗ್ಗೆ ಏನ್ ದಾಖಲೆ ಕೊಟ್ರಿ ನೀವು?
ಅಲ್ಲಿ before the at the first instance, my lord, the second appeal has been filed. Application filed under order 41 rule 27. And have produced the 40 documents. That is include the transfer certificate along with all the public documents.
That is in appeal.
This honorable court allowed the appeal. Consequently, suit came to be decreed. As against that, my lord, the respondent, first respondent alone preferred an appeal before the apex court. Apex court, the setting aside the judgment and decree passed by this honorable court, and the matter has been remanded before the first appellate court in order to examine the application filed under order 41 rule 27.
Witnesses na
ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ರು, ಫಸ್ಟ್ again, my lord, the first appellate court rejected the application filed by the plaintiff under order 41 rule 27. Writ petition has been filed. That application came to be allowed. Thereafter, my lord, the first appellate court, my lord, they remanded the matter before the trial court for limited purpose to recording the evidence based on the documents produced along with application. Whatever the documents which were placed before this honorable court at the first instance, very same documents has been, my lord, they has examined before the trial court. And apart from
once the Supreme Court set aside the order of this court,
and the matter
remanded the matter to the first appellate court. Once again, why there was a remand to the trial court?
ಅಲ್ಲ, ಅದು ಲಿಮಿಟೆಡ್ ಪರ್ಪಸ್ ಟು ಹೆಲ್ಡ್ ಅನ್ ಎನ್ಕ್ವೈರಿ ಆನ್ ದಿ ಅಪ್ಲಿಕೇಶನ್.
ಅದ್ರ ಮೇಲೂ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್
ಮಾಡಬಹುದಾಗಿತ್ತು. ಅವರು ರಿಮೈಂಡ್ ಅಲ್ಲಿ ರೆಕಾರ್ಡ್ ಎವಿಡೆನ್ಸ್ ಮಾಡಕ್ ಟ್ರಯಲ್ ಕೋರ್ಟಿಗೆ ಮಾಡಿದ್ರು. ಮೆಲಾಡ್ ದಿ ಅಪಾರ್ಟ್ ಫ್ರಮ್ ದಟ್, ಇನ್ ಆರ್ಡರ್ ಟು ಮೆಲಾಡ್ ದಿ ದೋ ಇನ್ ದಿ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ he denied the paternity of the plaintiff with the father. Melod, it is Melod, the Hanumanthaya is the prepositor. He had two wives. The plaintiff is the son through first wife, and the defendants, Melod, they are the children through second wife. In order to establish the paternity, Melod, the own brother of the Hanumanthaya has been examined before the trial court. My lord, he is none other than the uncle of the plaintiff and defendant. He specifically deposes that, my lord, when the marriage has taken place, when the plaintiff mother died, when he got second married.
Supreme Court to consider the application under Order 41 Rule 27 by the Appellate Court. Appellate Court once again should not have sent it back to the trial court. Ought to have recorded the statement of the witnesses in the Appellate Court itself, and considering the additional documents would have given the finding. Alva?
No, the first
One
appellate
day
court has given the
one day on the
findings.
request, my lord. What happened? So far as, my lord, the other defendants, they are agreed with, my lord, the allotted the share in favor of the
ಈಗ
plaintiff.
ಇನ್ನೊಂದು
Now,
ಈ ಅಪೀಲ್ ಅಲ್ಲಿ ಅವರು R2 to 4 and 7 ಗೆ ಮಾತ್ರ ಹಾಕಿದ್ದಾರೆ. R1
ಅಲ್ಲ R1 ಗೆ ಮಾತ್ರ
5 and 6 ಗೆ ಹಾಕಿಲ್ಲ. ಅವ್ರಿಗೆ ನೋಟಿಸ್
ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಹೋಗ್ಲಿ ಒಂದು. ಆಮೇಲೆ ಅಪಾರ್ಟ್ ಫ್ರಮ್ ದಟ್, ಮೈ ಲಾರ್ಡ್, ನೌ ಔಟ್ ಆಫ್ 5 ಐಟಮ್ಸ್ ಆಫ್ ದಿ ಸೂಟ್ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ, ಇಲ್ಲಿ ಜಾಸ್ತಿ ಇಲ್ಲ, 1 ಎಕರೆ 33 ಗುಂಟೆ ಎಲ್ಲ 1 ಎಕರೆ ಒಳಗೆ ಇರೋದು. He is already alienated, my lord, 2 items of the property, that is during pendency of the appeal.
Pendency of the appeal subject to the list ಅಷ್ಟೇ.
Of the appeal.
Pendency of the appeal subject to the list ಅಷ್ಟೇ. Even if it is sold.
And so far as other,
if you succeeds in the appeal,
brother and sisters,
then equity.
Allah, our brothers and sisters, they are agreed for settlement with the plaintiff. Only the first son alone, my lord, the legal heirs of the first defendant alone, he is denying.
Issue notice against R1 and 5 and 6. ಅಷ್ಟೇನಾ ಇರೋದು? 7 ಆದ್ಮೇಲೆ ಇನ್ಯಾರು ಇಲ್ವಾ?
ಇಲ್ಲ.
ಇನ್ಯಾರು ಇಲ್ಲ. In the meanwhile, registry is directed to call for records of the trial court and appellate court. 8 ಇದಾರಾ? 8 also. Is this matter on 23/8? 53.
Got 20 untas of land in this. Got 20 untas of land in the suit property from my father. We are not the parties to that partition deed, and we are challenging before the Assistant Commissioner and also DC and the Assistant before the Tahsildar regarding the alienation made and MRs created in favor of the first respondent, and also subsequently he sold this 20 untas on 21/3 to 2000 to respondent's father, Marivucha, who is now dead. He was also a party in the original suit. According to us, my father had only one wife, and out for him 2 daughters, and had only one wife, and out for him 2 daughters and 4 sons are there, and this respondent is a stranger, and he cannot claim any share from my father's property, the ancestral property. We are not the party to the partition suit, partition deed that was alleged to have been executed my father in favor of the first respondent. And the trial court has ignored the contents taken by the plaintiffs for a declaration injunction to declare that the suit property belongs to the only to the plaintiffs, and also for a consequence of permanent injunction. In the original suit, this first defendant has not filed his written statement, and he has also not come before the court and give any evidence. And only on the evidence of respondent number 2, that is the son of.
You are seeking the relief of declaration.
Yes, yes, madam.
On what basis?
That it is the 20 quintas that which has been sold, alleged to have sold my father, that is partition my father to first, and subsequent sale deed created by the first respondent, that is Rajappa, in favor of Marivuchaya, is also not binding on us, and the partition deed also not binding on us. Deed also not binding on us.
But trial court comes to the conclusion that you are not the owner of the property.
We are the owners of the property. We are the owners
Other
of
what,
property.
on what basis?
We have produced this family tree, partition deed, and also our
Partition between whom?
between my father,
Ah.
Javaraya, and the respondent 2 to 3's father, one Marihuchaya, who is brother of elder brother of my father.
Aito.
In that partition, we got our father got a share of this suit schedule property. And it is subsequently they contended that on 21/5/1997 through a registered partition deed, my father gave this 20 guntas of land of the suit schedule property to first respondent, that is Rajappa. He claims that he is one of the son of my father through a second wife, Mariamma. There is no second wife. Only Mariamma is our mother. And that said, Mariamma had got two children, 6 children, 2 daughters and 4 brothers, sons.
If a property comes to the father, it becomes a separate property, not the ancestral property.
It was got through partition by him.
Maybe.
It is ancestral property. It was earned by Kamaya.
The ancestral property in 3 generations ತೋರ್ಸಕ್ಕೆ ಏನಿದೆ material ನಿಮ್ಮ ಹತ್ರ?
Documents ಎಲ್ಲ ಕೊಟ್ಟಿದ್ರು.
ಏನ್ ಕೊಟ್ಟಿದ್ರಿ? ಏನು ಇಲ್ವಲ್ಲ. That's why the trial court comes to the conclusion that you cannot be declared as the owner of the property. Content that defendant number 1 has sold the suit schedule property in favor of one Marihuchaya. Marihuchaya sale deed ಆಗಿದೆ. 31/5/2000 ಅಲ್ಲೇ.
Marihuchaya is none other than the father of this defendant numbers 2 and 3. And we prepared a revenue appeal regarding the alienation, that is MRs made by the revenue office.
ಏನು ಗೊತ್ತೆ ನಮ್ಗೇನೋ ಅರ್ಥ ಆಗ್ತಿಲ್ಲ. ರೆಕಾರ್ಡ್ಸ್ ಬರ್ ನೋಡೋಣ, ನಾವೇ ರೆಕಾರ್ಡ್ಸ್ ನೋಡಿ ಡಿಸೈಡ್ ಮಾಡಿ. ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ ಯಾವ ಊರಿಂದ ಬರ್ಬೇಕು ರೆಕಾರ್ಡ್ಸ್?
IA number 1 and 2 make kindly.
Records ಬರ್ಲಿ. First of all, I am not convinced with the grounds. Records, the registry is directed to get the records of trial court and appellate court and list this matter on 23/8. Next, 54.
Proxy counsel, my lord. Respondent's counsel, there is a death in the respondent's family. Counsel's family is not there in station.
So, proxy counsel seeks time on the ground that there was a death in the family of
counsel
appears on behalf of the respondent. And appellant counsel is present.
Lord, the execution petition is already there, my lord.
Not precipitated ಅಂತ ಆರ್ಡರ್ ಆಗಿದೆ ಅಂತ.
ಅಂಡರ್ಟೇಕಿಂಗ್ ತಗೊಂಡಿದ್ರು ಅವರು, not to precipitate.
Extend ಮಾಡೋಣ ಅಷ್ಟೇ. And the undertaking given earlier that not going to precipitate the matter is extended till next date of hearing. List this matter on 7/8.
Grateful.
55 already urgent. 56 Prasanna Shetty.
My lords, for the appellant in this case, my lords, I'm for the appellant. My lords, the senior is held up in number 18 court or some short date maybe.
Let him be there. You argue.
My lords, I am not aware of the.
Last time kuda matter was listed. Kudi an order sheet.
My lords,
but it's a eviction suit which has been concurrently
my lords,
declared.
my senior.
2400 4800 ಕೊಡಿ ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ.
2016ರಿಂದ ಬಾಡಿಗೆ ಕೊಟ್ಟಿಲ್ಲ.
My lords, my senior is held up in court.
Appellant files memo stating that RS number is also filed and the same is also filed against the very same respondent and Durham counsel also. Connect appeal. There is no order to connect appeal in RSA 533 along with this appeal. ಹೇಳ್ರಿ ಬಾಡಿಗೆ ಕೊಟ್ಟಿಲ್ಲ
My
ಅಂತ.
senior is held up in court on 18, my lords, some short date.
Get him.
My lords,
ಬಾಡಿಗೆ ಕೊಟ್ಟಿಲ್ಲ ಅಂತಲ್ರಿ.
My lords.
2017ರಿಂದ 16ರಿಂದ
ಕೊಟ್ಟು
ಮತ್ತೇನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? You cannot squat on the property without payment of rent.
My lords,
Relationship ಎಲ್ಲ
No, that is not denied. It's a, not the.
not denied.
Respondent is a trust. It's a.
ವಾಣಿಜ್ಯ ಸಂಕೀರ್ಣವನ್ನು
ಹೌದು.
ವಾದಿ ಸಂಸ್ಥೆಯವರು ಕಟ್ಟಿರುತ್ತಾರೆ ಅಂದ್ರೆ ಸರಿ, ವಾದಿ ಸಂಸ್ಥೆ ತನ್ನ ಸ್ವಾಧೀನದಲ್ಲಿ ಅಂಗಡಿ ಕೊನೆಯ ತೆರಿಗೆಯನ್ನು ಕಟ್ಟುತ್ತಿದೆ ಅಂತಾರೆ ವಾದಿ. ನಾನು ಕಟ್ಟುತ್ತಿದ್ದೇನೆ, ತೆರಿಗೆ ರಸೀದಿಗಳು ನನ್ನ ಸ್ವಾಧೀನದಲ್ಲಿರುತ್ತವೆ.
my lords.
Now what they
Taken
say, my lords, is that the plaintiff trust has encroached upon government land is what they contend. At this stage. Of course, that, my lords, is subject matter of a petition. There is a stay order.
Last time I ಹೇಳಿದೆ
ಹೌದು.
Your status is only a tenant. You cannot question the title of the landlord once you admit that you are a tenant. ಹೌದಲ್ಲ?
Correct, my
ಮತ್ತೆ
lords.
ರೆಂಟ್ ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ?
My lords, my senior is.
ವಾದಿ ಸಂಸ್ಥೆ ಪರವಾಗಿ ಸಹಿ ಇರುತ್ತದೆ ಎಂದರೆ ಸರಿ. 4 ಪುಟಗಳಲ್ಲಿ ನನ್ನ ಸಹಿ ಇರುತ್ತದೆ. ಎಲ್ಲ ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡಿದ್ರಲ್ಲ ಎಕ್ಸಿಬಿಟ್ P7 ಅಲ್ಲಿ.
Small tenement.
2400 ರೂಪಾಯಿ ಬಾಡಿಗೆ ನೀಡಲು ಒಪ್ಪಿರುತ್ತೇವೆ ಎಂದರೆ ಸರಿ.
My lords,
ಅದನ್ನೇ
my
ಕೊಡಿ ಅಂತ ದುಡ್ಡು ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. ಹಾ ಹೇಳಿ. ಅಲ್ಲ ಬಾಡಿಗೆ ಕೊಡಿ ಫಸ್ಟ್, ಆಮೇಲೆ ನೋಡೋಣ. ಡೇಟ್ ಕೊಡೋಣ, ಒಂದಲ್ಲ 2 ವಾರ ಕೊಡ್ತೀನಿ. 2 ವಾರ ಕೊಡ್ತೀನಿ. ಯು ಕೆನಾಟ್ ಸ್ಕ್ವಾಟ್ ಆನ್ ದಿ ಪ್ರಾಪರ್ಟಿ ವಿತೌಟ್ ಪೇಮೆಂಟ್ ಆಫ್ ರೆಂಟ್. ಕರ್ಸಿ ಕೊಡೋದಿಲ್ಲ ಡೇಟ್. ಫಸ್ಟ್ ಬಾಡಿಗೆ ಕಟ್ಟಿ, ಅರಿಯರ್ಸ್ ಕೊಡಿ, ಬಾಡಿಗೆ ಕೊಡಿ. ನೀವು ಬಾಡಿಗೆನೂ ಕೊಡಲ್ಲ, ಖಾಲಿನೂ ಮಾಡಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗ್ರಿ? ಯು ಕೆನಾಟ್ ಸ್ಕ್ವಾಟ್ ಆನ್ ದಿ ಪ್ರಾಪರ್ಟಿ ವಿತೌಟ್ ಪೇಮೆಂಟ್ ಆಫ್ ರೆಂಟ್. ನೆಕ್ಸ್ಟ್
57 ಕೆ ಪ್ರಸನ್ನ ಶೆಟ್ಟಿ.
ಅದು ಅವ್ರದೇ ಅಪ್ ಟು 58. ಯಾವ್ದು ಪಾರ್ಟ್ ಇದೆಯಾ ಮೇಡಮ್ ಇಲ್ಲಿ? ಬಂದ್ರ ಅವರು? ಅವ್ರ ಅಸಿಸ್ಟೆಂಟ್ ಸಿಗಲ್ಲ ಅಂತ ನಾನೇ ಫೈಲ್ ತಗೊಂಡೋಗಿ ಮನೆಗೆ ಹೋಗಿ ಓದ್ಕೊಂಡ್ ಬಂದೆ. ಲಾಸ್ಟ್ ಟೈಮೇ ಹೇಳಿದ್ದೆ. ಈಗ 2 ಸರಿಲೂ ಕರೆದ್ರೆ ಅವರೇ ಇಲ್ಲ, ನಾಪತ್ತೆ. I've already dictated half judgment. At that time he misguided the court. ಎಲ್ರಿ ಅವರು? ಬೆಳಗ್ಗೆನೂ ಇಲ್ಲ, ಈಗ್ಲೂ ಇಲ್ಲ. ಬಂದಿದ್ದೀರಾ? ನಾಡಕ್ ಹಾಕಿರಿ ನೋಡೋಣ.
ಪಾರ್ಟಿಷನ್ ಆಗಿ ಆಲ್ರೆಡಿ ಆಕ್ಟೆಡ್ ಅಪಾನ್ ಆಗಿದೆ ಸರ್.
ಪಾರ್ಟಿಷನ್ ಆಕ್ಟೆಡ್ ಅಪಾನ್ ಆಗಿದೆ. 2 ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆ. ಎಕ್ಸಿಬಿಟ್ D14.
D14
and exhibit P1.
P1 and D14, my lord. The first appellate court in para number 41 to 49 elaborately discussed about the exhibit P1 and D14.
Already there was a partition anta.
Yes, my lord. Admission ಇದೆ, clear admission ಕೊಟ್ಟಿದ್ದಾರೆ.
Admission ಇದೆಯಾ?
Yes, my lord. ಅವ್ರ ತಂದೆ ಡ್ಯೂರಿಂಗ್ ದಿ ಲೈಫ್ ಟೈಮ್ ದಿ ಸೆಡ್ ದೊಡ್ಡಪ್ಪ sold the some properties. Thereafter exhibit P1 came to away. He is the signatory of the exhibit P1, my lord. After his death in 2015 one more partition is affected between the appellants, my lord, appellants family.
Third, appellant in the early morning, ಬೆಳಿಗ್ಗೆ ಪಾಸ್ ಓವರ್ ಆಯ್ತಲ್ಲ ಮೇಡಮ್, early morning and also in the afternoon, no representation by the appellant counsel and counsel for the respondent is present in both the occasions. However, in the ends of justice, one more opportunity is given to the appellant counsel. If appellant counsel doesn't appear in the next date of hearing, appeal will be dismissed. This matter day after tomorrow. Next. Final hearing.
Just one. 59.
59. R. Kumar.
For respondent,
Announcement for compensation, my lord.
kindly have it on day after tomorrow.
Yakri,
Senior is in quota number 1.
Yar nim senior.
KSB.
2016 matter idu.
Day after-
MSA.
Day after tomorrow.
ಇನ್ನೊಂದು ವರ್ಷ ಬಂದ್ರೆ 1 decade.
Review petition dismissed, my lord, this honorable.
Now this court already dismissed the review petition.
Yes, ma'am.
Same ಐದು ಅದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದ. ಈ 59, 60, 61 ಎಲ್ಲ ಕನೆಕ್ಟೆಡ್.
Similar issue.
Connected, similar.
Similar ಆ ಏನು?
Similar.
ಬರ್ತಾರ ನೋಡಿ, ಪಾಸ್ ಓವರ್ ಮಾಡಿರ್ತೀನಿ.
Day after tomorrow.
ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಎಲ್ಲ ಇಲ್ರಿ, ಲಾಸ್ಟ್ ಡೇ ಎಲ್ಲ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಇನ್ನಿರೋದೇ 2 ದಿವಸ ಕೆಲಸ ಮಾಡಕ್ಕೆ.
ಅಲ್ಲೂ ನಮ್ದೇ ಆಗ್ತದೆ.
This matter up to 2 weeks. ತಗೊಳ್ಳಿ. 7, 8.
ಮಚ್ಚು.
3 ಎಲ್ಲದರಲ್ಲೂ ಭೀಮಾ ಏನೇನಾ?
ಹೌದು.
7, 8. 59, 60, 61.
This honorable court was pleased to direct Parrot to post the matter for final hearing. However, the matter was not. Honorable court was pleased to direct Parrot to post the matter for final hearing. However, the matter was not admitted. But there is an order to post the matter for final hearing.
Without admitting the matter, my lord.
ಆಯ್ತು, ಲಿಸ್ಟ್ ದಿ ಮ್ಯಾಟರ್ ಫಾರ್ ಅಡ್ಮಿಷನ್ ಅಂತ ಹಾಕ್ಬಿಡಿ ಅಷ್ಟೇ.
Much obliged.
ಲಿಸ್ಟ್ ದಿ ಮ್ಯಾಟರ್ ಫಾರ್ ಅಡ್ಮಿಷನ್ 59, 60, 61. ಅವಾಗ ಅಲ್ಲಿ ಬೇಗ ಬರುತ್ತೆ, ಅವಾಗ ಮಾಡ್ಕೊಡಿ.
ಮಚ್ಚು.
62.
ಹರೀಶ್ ಕುಮಾರ್ ಅಂಡ್ RBS. ಸಬ್ಸ್ಟಾಂಟಿವ್ ಕ್ವಶನ್ ಆಫ್ ಲಾ ಕೊಡಿ.
MSc.
MF ಏನಾ?
MSA.
ಕೊಡಿ ಏನದು ನೋಡು. ಅದರ್ ಸೈಡ್ ಇಲ್ವಾ?
ಇಲ್ಲ ಇದ್ರು.
ಈಗ ಇದ್ರಲ್ಲಿ ಇಲ್ಲ ಓಡಾಡ್ತಿದ್ರಲ್ರಿ. Matter is remanded to the trial court for framing additional issue with regard to the alleged will dated 21/11/2005 and opportunity to both parties to adduce additional evidence and then to dispose of the matter afresh in accordance with law as expeditiously as possible, that is within 4 months. What is the error in the order?
The plaintiff has moved this application for additional evidence and amendment of the plaint. It totally changes the nature of the suit. On merits, the first appellate court had come to the conclusion that the finding of the court is the appellant has not made out any case for interfering with the finding. However, only to give an opportunity, it has to be remanded.
Suit for declaration and permanent injunction.
There were 2 suits. One suit filed by the appellant herein, claiming he is the brother of the deceased. Whereas the respondent, he claiming to be the husband, he filed another suit for declaration. In first instance, the suit filed by the appellant came to be dismissed, and the other suit was allowed. Challenging that appeal came to be filed. It was remanded. After remand, the suit filed by the appellant came to be allowed. The other suit came to be rejected. In the appeal, for the first time, the will was introduced. Now kindly see, the finding is that only to give an opportunity. If that is the case, it should not have been.
In the original suit, they have not taken any plea regarding
will. There was no will at all. After 13 years, for the first time it was introduced.
Both are beneficiary under the will. One side, it is given to one portion of the, my suit dismissed and his suit decreed. And appellate court, my lord, remanded to establish the, my lord, the relationship. Once again, my lord, the trial court, my lord, dismissed. After came to, my lord, I came to know that, my lord, the testator, my lord, she has executed a, my lord, bequeath property equally in favor of the plaintiff as well in my favor also, my lord.
That is the registered will?
The registered will.
What is the recital in that will regarding the relationship between the parties? Was there any recital in the document of will that admitting both the parties are?
ಮೇಲ್ಕಂಡ ನನಗೆ ಇದು ಓದ್ಬಿಡ್ತೀನಿ. ಮೇಲ್ಕಂಡ ನನಗೆ 65 ವರ್ಷ ವಯಸ್ಸಾಗಿದ್ದು ನಾನು ಹಾಲಿ ನನ್ನ ಅಣ್ಣನಾದ ಎಸ್.ಕೆ. ಮಂಜುನಾಥ್ ಬಿನ್ ಕರಿಯಪ್ಪ ಮತ್ತು ನನ್ನ ಬಂಧು ಶ್ರೀಕಂಠಪ್ಪ ಬಿನ್ ಚೆನ್ನಪ್ಪ ಇವರುಗಳ ಜೊತೆಯಲ್ಲಿ ನನ್ನ ವೃದ್ಧಾಪ್ಯ ಜೀವನವನ್ನು ಸಾಗಿಸುತ್ತಿದ್ದು ನನ್ನ ಎಲ್ಲಾ ರೇಖೆಗಳನ್ನು ನನ್ನ ಅಣ್ಣ ಎಸ್.ಕೆ. ಮಂಜುನಾಥ್ ಮತ್ತು ನನ್ನ ಬಂಧು ಶ್ರೀಕಂಠಪ್ಪ ಅಂದ್ರೆ ನಾನು ಇವರುಗಳೇ ನೋಡಿಕೊಳ್ಳುತ್ತಿದ್ದಾರೆ. ಇನ್ನು ಮುಂದೆಯೂ ಸಹ ಇದೇ ರೀತಿ ನೋಡಿಕೊಳ್ಳುತ್ತಿರುವ ಭರವಸೆ ನನಗೆ ಇರುವುದರಿಂದ ನಾನು ಇನ್ನೂ ಹೆಚ್ಚು ಕಾಲ ಬದುಕುವ ಭರವಸೆ ಇಲ್ಲದೆ ಇರುವುದರಿಂದ ನನ್ನ ಹೆಸರಿನಲ್ಲಿ ಖಾತೆ ಇರತಕ್ಕ ಶೆಡ್ಯೂಲ್ ಸ್ವತ್ತು ನನ್ನ ಮರಣಾನಂತರ ನನ್ನ ಅಣ್ಣನಾದ ಎಸ್.ಕೆ. ಮಂಜುನಾಥ್ ಮತ್ತು ನನ್ನ ಬಂಧು ಶ್ರೀಕಂಠಪ್ಪ ಅವರುಗಳಿಗೆ ಶೆಡ್ಯೂಲ್ನಲ್ಲಿ ವಿವರಿಸಿರುವ ಪ್ರಕಾರ ಸೇರಬೇಕೆಂದ ಸದುದ್ದೇಶದಿಂದ ಅಲ್ಲದೆ ನನ್ನ ಮರಣಾನಂತರ ನನ್ನ ಇತರೆ ವಾರಸುದಾರಗಳಲ್ಲಿ ಯಾವುದೇ ಭಿನ್ನಾಭಿಪ್ರಾಯ ಬರಬಾರದೆಂದು ಸದುದ್ದೇಶದಿಂದ ವಿಲ್ ಪತ್ರವನ್ನು ಬರೆಸಿಡುವುದು ಸೂಕ್ತವೆಂದು ತಿಳಿದು ಈ ವಿಲ್ ಪತ್ರವನ್ನು ಬರೆಸಿಟ್ಟಿರುತ್ತೇನೆ. ನನ್ನ ಹೆಸರಿಗೆ ಇರತಕ್ಕ ಸ್ವತ್ತು ನನ್ನ ಮರಣಾನಂತರ ನನ್ನ ಅಣ್ಣನಾದ ಎಸ್.ಕೆ. ಮಂಜುನಾಥ್ ಮತ್ತು ನನ್ನ ಬಂಧು ಶ್ರೀಕಂಠಪ್ಪಯವರುಗಳಿಗೆ ಶೆಡ್ಯೂಲ್ನಲ್ಲಿ ವಿವರಿಸಿರುವ ಪ್ರಕಾರ ಸೇರತಕ್ಕದು. ಸದರಿ ವಿಲ್ ಪತ್ರವನ್ನು ನನ್ನ ಸ್ಟೂಡೆಂಟ್ಸ್ ಬುದ್ಧಿ ಜ್ಞಾನ ತಿಳುವಳಿಕೆ ಆರೋಗ್ಯ ಎಲ್ಲ ಸರಿಯಾಗಿ ಇರುವಾಗಲೇ ಯಾರ ಒತ್ತಾಯಕ್ಕೂ ಮಣಿಯದೆ ಸರಿ ವಿಲ್ ಪತ್ರವನ್ನು ಬರೆಸಿ ಓದಿಸಿ ಕೇಳಿ ಸರಿಯಾಗಿದೆ ಎಂದು ಮನವರಿಕೆ ಮಾಡಿಕೊಂಡು ಈ ಪತ್ರಕ್ಕೆ ಸಾಕ್ಷಿ ಹಾಕಿರುವ ಸಮಕ್ಷಮ ರುಜು ಮಾಡಿ ರಿಜಿಸ್ಟರ್ ಮಾಡಿಸಿರುತ್ತೇನೆ. ನನ್ನ ಮರಣಾನಂತರ ನನ್ನ ಅಣ್ಣನಾದ ಎಸ್.ಕೆ. ಮಂಜುನಾಥ್ ಮತ್ತು ನನ್ನ ಬಂಧು ಶ್ರೀಕಂಠಪ್ಪಯವರುಗಳು ಶೆಡ್ಯೂಲ್ ನಲ್ಲಿ ವಿವರಿಸಿರುವ ಪ್ರಕಾರ ತಮ್ಮ ತಮ್ಮ ಹೆಸರಿಗೆ ಸ್ವತ್ತಿನ ಖಾತೆಯನ್ನು ವರ್ಗಾವಣೆ ಮಾಡಿಕೊಂಡು ಅವರವರ ಇಷ್ಟಾನುಸಾರ ಸುಖದಿಂದ ವಿಲ್ ಮರಣ ಶಾಸನದ ಸಹಿ.
The whole case is that he is the husband of the deceased. Now, no, he utterly failed to prove that. Even the will what he produced, my lord, it doesn't disclose that he was the husband. Under such circumstances, the finding given by the court below, as far as these two suits are concerned, that becomes final. And my lord, now only if at all he is entitled under the will, my lord, separate suit can be filed.
I am permitted to cite this, my lord. The pendency of the appeal.
This finding need not be disturbed because even they failed as far as the status of the husband is concerned.
My lord, would like to take, my lord, the para 3.
Registered will alva?
ಹೌದು. ಇಲ್ಲೂ ಅಷ್ಟೇ ಅಪೀಲ್ ಪೆಂಡಿಂಗ್ ಇದ್ದಾಗ ಇಟ್ ವಾಸ್ ಬ್ರಾಟ್. ಸಾರಿ. Para 3. In the above appeal, the appellants have filed the application for production of the document stating that para 3, there is a will by late Channegoda to Mr. Babu Goda in respect of the item number 2 to 8 of the suit schedule property. In view of the production of the said document, the veracity and genuineness need to be decided by the court after trial. It is prayed this honorable court may remand the case to the first additional senior civil judge Mangalore to give a findings on the alleged will. The other respondents are duly served and unrepresented. Having regard to the contentions urged by the appellants in the memorandum of appeal and in view of the application IA number 2 of 15 seeking production of the will, this is alleged to have been discovered after the pronouncement of the judgment and decree passed by the trial court. It is necessary to call for findings on the said will, as it is stated that the existence of the said will came to the knowledge of the appellants only after the decree of the decretal of the suit. The matter is required to be remanded to the trial court to record the findings on the said issue. Hence, to the limited extent, the application IA.
The whole finding on the other issues should not have been disturbed.
Other issues ಏನಿದೆ?
See, the whole case is that he is the husband. As far as that issue is concerned, the court has come to the conclusion that he failed to prove
ಈ
it.
appeal ಅಲ್ಲಿ ಆರ್ಡರ್ 41 ರೂಲ್ 27 ಸಪರೇಟ್ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದಾರೆ. ವಿಲ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದಾಗ
ಇಲ್ಲ
ಆರ್ಡರ್ 6 ರೂಲ್ 17 ಇದೆ.
ಅಲ್ಲ, ಅದು ವಿಚಾರಣೆ ಮಾಡಲೇಬೇಕಾಗುತ್ತೆ.
ಅಡಿಷನಲ್ ಎವಿಡೆನ್ಸ್ ಹಾಕಿದ್ದೀರಾ ನೀವು?
ಹೌದು.
ಎಲ್ಲಿದೆ ಅಪ್ಲಿಕೇಶನ್ ಅಂತ ಕೇಳಿದೆ. ಆರ್ಡರ್ 6 ರೂಲ್ 17 ಸಪರೇಟ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀರಾ ಅಂತ?
ಹಾಕಿದ್ದೀನಿ.
ಅದೇನಾಯ್ತು? ಸಪರೇಟ್ ಆರ್ಡರ್ ಮಾಡಿದಾರ ಅಲಾಂಗ್ ವಿತ್ ಮೇನ್ ಅಪೀಲ್?
ಅಲಾಂಗ್ ವಿತ್ ಮೇನೆ ಮಾಡಿದ್ದಾರೆ.
ಎಲ್ಲಿದೆ ಅದು ಪಾಯಿಂಟ್ ಫಾರ್ ಕನ್ಸಿಡರೇಷನ್?
ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾತ್ರ ಅಲೋ ಮಾಡ್ಕೊಂಡು ಇಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ರಿಮ್ಯಾಂಡೆಡ್.
Whether the appellant has made out a sufficient ground to IA number 1 to 3 ಅಂತಿದೆ. 1 to 3
ಮೂರು ಅಪ್ಲಿಕೇಶನ್. ಏನೇನದು? 1 to 3 ಆರ್ಡರ್ 6 ರೂಲ್ 17 ಒಂದು, ಆರ್ಡರ್ 41 ರೂಲ್ 27 ಒಂದು, ಆರ್ಡರ್ 12 ರೂಲ್ 8 ಒಂದು.
ಪಾರ್ಟ್ಲಿ ಇನ್ ಅಫರ್ಮೇಟಿವ್ ಮಾಡವ್ರೆ. ಯಾವುದು?
3 ನ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರು.
3 ಏನು?
To summon the document from us, the will.
Or 12 rule 8.
Summon the
original will from us.
ನಿಮ್ಮ ಹತ್ರ ಒರಿಜಿನಲ್ ವಿಲ್
ಅಂತ ಇದೆ ಅಂತ ಅವರು ಸುಮ್ಮನೆ ಹೇಳಿ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರು.
ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಹಾಕಿದಾರಾ?
ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಹಾಕಿದ್ದಾರೆ.
ಬೇರೆ ಇದೆ, ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಇದೆ.
ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ದೇ ಹ್ಯಾವ್ ಫೈಲ್ಡ್.
ಅಯ್ಯೋ, ಒನ್ ಏನು?
One is amendment.
Order 6 rule 17. ಹೌದು.
Amendment of
plaint. IA2 for additional evidence.
41 rule 27.
41 rule 27 along with certified copy. IA3 is only
to summon
Order 12
original
rule
from you. Third.
No, the thing is that, my lord, it is as far as the finding which on the two suits are final. Now only their contention is that based on will. If that is the case, only for the limited purpose to hold an inquiry on the will aspect is concerned, that may be as cited, as it was decided in the cited decision. Only for that purpose. Now, an entire judgment and degree has been set aside.
Both.
Is allowed. Hence, my lord, additional issue has been framed and matter has been remanded. It is true that without pleadings in respect of the alleged will and without producing the certified copy of the said will, it is very difficult for the trial court to give findings on the main issues. Therefore, I am of the view that IA number 1 filed by the appellant under Order 6 Rule 17 read with 151 and IA 2 Order 41 Rule 27 shall have to be allowed accordingly. IA number 1 and 2 are hereby allowed. Shall have to be allowed accordingly. IA number 1 and 2 are hereby allowed. However, the appellants are not made out a sufficient grounds to IA number 3 because the respondent has not admitted about the possession of the registered will dated 21/11/2005 with him. Therefore, this court cannot direct the respondent to produce the said will. Consequently, IA number 3 is rejected. If the matter is remanded to the trial court for the limited purpose as stated above, no injustice would be caused to the respondent. To the trial court for the limited purpose as stated above, no injustice would be caused to the respondent. On the other hand, if the matter is remanded to the trial court for the above purpose, definitely
In one way they say that limited purpose. If the limited purpose, judgment should not have been set aside. Only the finding on that will should have been called for.
Next,
judgment set aside ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ ಈಗ ಆ will ಮೇಲೆ ಕೆಳಗಿನ ಕೋರ್ಟ್ ಫೈಂಡಿಂಗ್ ಕೊಡಬೇಕು ಅಂತಂದ್ರೆ ವಿತೌಟ್ ಸೆಟ್ಟಿಂಗ್ ಅಸೈಡ್ ದಿ ಜಡ್ಜ್ಮೆಂಟ್
ಅಲ್ಲ, finding has to come to the first appellate court as sought in this in the judgment what my learned friend has quoted.
Third, heard the appellant counsel and also the counsel appearing for the respondent. Connected ಇನ್ನೊಂದಿದೆಯಾ ಸೇಮ್
ಅದೇ ಎರಡು suit
connected.
There are two suits. ಆಯ್ತು. Heard both the counsels appearing for the appellant and also the respondents. These two MSAs are filed challenging the judgment and decree passed in RA number 67 of 2017 and 68 of 2017, wherein the first appellate court by allowing IA number 1 and 2 filed under Order 6 Rule 17 as well as IA number 2 under Order 41 Rule 27 allowed those two applications and that the will is propounded after more than a decade. An amendment allowed by the trial court is also erroneous and ought not to have allowed the amendment as well as remanded the matter for fresh consideration. The counsel also would vehemently contend that when the will is produced and if the court comes to the conclusion that in order to decide the issue involved between the parties, production of will is necessary, ought to have remanded the matter only for the limited purpose to examine will is necessary, ought to have remanded the matter only for the limited purpose to examine in respect of will is concerned, and ought not to have set aside the entire judgment of the trial court. For contra, the counsel appearing to the respondent would contend that only on searching of document found, searching of document found the will and the same is also a registered will. And also counsel would contend that in terms of the will, appellant as well as the respondent who propounded the will are the beneficiaries under the will. And when such being the case, trial court not committed any error in allowing the application of Order 6 Rule 17. And while seeking for the production of additional document, pleading is necessary and hence amendment application is allowed. And in order to adduce evidence also, there must be a pleading. And also having taken note of the will was executed. And in order to decide the same, rightly allowed the applications IA number 1 and 2 and remanded the matter to the trial court to decide the same. The counsel in support of his argument also relied upon the order passed by this court dated 4th day of March 2020 with a time bound limit, and hence the appellant counsel cannot find fault with the order of the trial court. Having heard the appellant counsel and also the counsel appearing for the respondent, And also considering the material available on record, the pointer to arise for the consideration of this court are whether the first appellate court committed an error in allowing of A number 1 and 2 and remanding the matter for fresh consideration. What order? Having perused the material available on record, it is not in that suit dispute that both suits are filed for the relief of declaration and permanent injunction. And also it is the contention in OS number 251 of 2006 that one B. Kariyappa and his wife Basamma of Sirigere village, Chitradurga Taluk has got plaintiff and a daughter S.K. Sarojamma, and they were the only children to them. The plaintiff's sister S.K. Sarojamma, who was much devotee of Akka Mahadevi, and she was accustomed to spiritual life, and she led the sacred life of spinster. She was a retired professor of Kannada in AVK College of Bapuji Education at Davanagere. And also it is contended that said S.K. Sarojamma was a member of Bapuji Education Association Employees House Building Cooperative Society Limited, Davanagere. The said society was allotted site number 32 for rupees 4,200 and building was the sale deed was executed by House Building Cooperative Society on 9/3/1989 in the name of S.K. Sarojamma. The said Sarojamma became the absolute owner and in peaceful possession of the enjoyment of the suit property. The said S.K. Sarojamma has very much love and affection on her brother, that is the plaintiff, who is the only brother, and there is no other brothers and sister except the plaintiff. The plaintiff has also had high love and affection with his sister, and they were always in very high, good, cordial terms, and both of them were ready to sacrifice each other, anything and everything. The said Sarojamma inclined to transfer the suit schedule property in favor of plaintiff in her lifetime by way of gift, but the plaintiff refused the same, as he told that the property be continued to be stand in her name till the end of her life. The plaintiff lived with his sister in the suit schedule property during her last days of years and still residing in the suit schedule property, and he continued his possession over the suit schedule property. It is also the contention that she had suffered possession over the suit schedule property. It is also the contention that she had suffered from so many ailments with cancer since last 5-6 years. The said Sarojamma died on 12/6/2006, leaving behind the suit schedule property. The father and mother of deceased S.K. Sarojamma were no more, and the plaintiff is the only full-blood uterine brother who succeeded to the estate of his deceased sister and become the absolute owner and in enjoyment of the suit schedule property, and hence contend that by successions he become the absolute owner of the property. The main contention of the defendant in the said suit that he married Sakamma, the first wife, when he was 20 years old. The doctors and astrologers told that she cannot get any children. Therefore, this defendant, at the instance of Shivakumar, she was aged about 16 to 17 years at Koratikere, in the presence of above said Swamiji. The parents of S.K. Sarojamma acted as a guardian for her. As promised, the defendant helped in educational institution. The defendant was running a Dalai shop.
Dallali shop.
Dallali shop in a seal bididar. Full stop. After the marriage of plaintiff, this defendant brought S.K. Sarojamma to Davangere and got her job in Bapuji Education, and therefore she was working in AVK College. The defendant was living with a Sarojamma in a rented building. This defendant got Sarojamma to become the member of Bapuji Educational House Building Cooperative Society. The said society allotted a site number 32, and defendant paid the said amount to the society through SK Sarojamma. The house was constructed by the society on the said site. The defendant has spent money for constructing extra needs of the said house. The sale deed was executed by the society in the name of SK Sarojamma on 29/3/1989. The plaintiff never used to come to the scheduled house. The plaintiff ill-treated his mother through she was a widow. Therefore, the mother of the plaintiff came to Davanagere in 1990 and lived in the suit scheduled house along with his defendant and SK Sarojamma. Afterwards, the plaintiff used to come to house with a view to see his mother. Then the plaintiff used to get money from SK Sarojamma by saying that he was no money even to purchase the ration. He got money from Paramashiva, who is the son of this defendant's younger brother. The plaintiff executed a pronote in favor of SK Sarojamma for an amount of rupees 28,000. Got from this defendant and his son Prashant. Got from SK Sarojamma in 1995. The plaintiff never helped in treating his mother when there was a fracture of her leg. The trial court, taking into note of the pleadings, the material on record, suit filed by the plaintiff in OS number 251 of 2006 is decreed, and other suit filed by the respondent is dismissed. That is OS number 299 of 2006. When the appeal was filed challenging both the appeals in RA number 67 of 2017 and RA 68 of 2017, the respondent come up with an application for amendment that the respondent found the will executed by Srimati Sarojamma and the same is produced before the appellate court and also sought for an amendment by filing an application under Order 6 Rule 17. The appellate court, having considered the pleadings as well as the application as well as the document produced, allowed those two applications, and though filed an application IA number 3 summoning the original will from the appellant herein, and the same was rejected. The appellate court, having considered both the appeals and also considering the application, comes to the conclusion that evidence requires to be recorded in respect of the will is concerned and remanded the matter. Having considered the reasoning given by the appellate court,